Move fast.
Good morning, Judge. Whenever you're ready to start, we're going to start with position number. Position 12, Mr. Geiger.
Hey, good morning.
Good day, good day.
Good morning, Your Honor.
Good morning. Position 12. This is going to be a non-negotiated plea,
Yeah, just
correct?
your time, Your Honor.
Good morning, Mr. Geiger. I'm Judge Eric Mora. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir, I do.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay. Do we have a calendar that has the recommendations? This one. Okay, that's all right. Good morning, Ms. Salette.
Good morning, Your Honor.
Is this your case?
Yes, Your Honor. The state's recommendation at this time is for the obstruction charge, credit for time served, for the public indecency charge, 12 months served, 90 days, credit for time served, 18 days, balance probated, psychosexual evaluation and treatment, and no inappropriate contact with the deputy, the victim in this case. That is, or Sergeant Finch Sergeant Finch, Finch. The reason for the state's recommendation, Your Honor, on November 11th, 2022, Sergeant Finch was retrieving inmates and observed the defendant with his genitals fully erected and exposed. The sergeant gave commands for the defendant to stop what he was doing, but the defendant continued to, I guess, continue to touch his genitals.
We stipulate to the
Okay. Yes, Your Honor. He does have he has actually two previous public indecency convictions. One from 2015 was a NOLO, and another one from 2015 as well. The defendant is also being held on a felony theft by shoplifting. But due to the defendant's previous public indecency convictions, and him continuing to pick up charges inside the Fulton County Jail, that's the basis for the state's recommendation at this time.
Thank you, Mr. Ford.
Thank you. Good morning, Your Honor.
Good morning.
We're asking for time served for Mr. Geiger. Mr. Geiger has spent 170 days in jail at this time. He's getting time served for the obstruction. We believe that he should also get time served for the public indecency as well. And so we're asking that you give him time served due to the fact that he's already completed 170 days. He has a job as a ghostwriter for music. He's 29 years old. He has good community support. I do have a telephone number for one of his relatives, which is his mother. He is a lifetime resident of the state of Georgia, Your Honor. We feel that the time that he's already spent in Fulton County Jail should suffice for this particular charge. So we're asking for time served, Your Honor, on both charges.
So you said 170 days, but I have down that he's only been in jail regarding this matter for 18 days. Is that correct?
That's correct, Your Honor, but I just stated that he has been in jail incarcerated for 170 days. In this case, because he was released, and then he's back in on the other charge, the other felony charge. That charge took place after this charge, Your Honor. So we're asking that he be given credit and that he be given time to, hold on. What did he do?
I've been locked up since June the 13th.
Okay, all right. That's all. I let the judge know that you've been in since for 170 days, so he'll take that into consideration. Okay.
Mr. Ford, I think that 60 days it would be appropriate on this case. So if he's going to take a plea, it's going to be 12 months to serve, 60 days, credit for time served, 18 days with the remainder of the request from the state.
Mr. Geiger, that means that you do 12 additional days instead of the time that the state would recommend was like 32 days. So the judges reduced your time to 60 days and not 90 days. Are you willing to plea at this time?
Peace in abundance, I do.
Okay, yes, we can continue, Your Honor. And we do,
right.
like I said, we do stick to the factual basis, venue and ID.
Thank you.
Okay, you can make it happen. You don't want to make it happen.
Mr. Geiger, it's my understanding that in case 22 CR 007769Y, you wish to plead guilty to willful obstruction of a law enforcement officer in public indecency. Is that correct?
I do.
Are you under the influence of any drugs or alcohol this morning?
No, I ain't.
You've been represented by counsel. Are you satisfied with your counsel's representation?
I am.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
I do.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept your plea, Mr. Geiger, for the willful obstruction, 12 months to serve, 18 days, credit for time served, 18 days, balance suspended. And on the public indecency, 12 months to serve, 60 days, credit for time served, 18 days, balance probated, a psychosexual evaluation and treatment if necessary, no further violent contact or inappropriate contact with Sergeant Finch, no drugs, alcohol, or weapons while on probation. I'm going to waive the probation fees to help you get and stay on your feet, but you're going to have to be on probation for the entire time, okay?
Yes, sir. May I please say something, sir?
That's up to your lawyer.
What are you gonna say?
I want to let him know I said my what is I don't even think
Yeah, but that's a felony. He can't do anything.
we can do whatever he can do. You got the power to do that.
Okay, all right. Go ahead, Mr. Geiger.
Hey, excuse me, sir. Excuse me, Judge Eric.
Yes, Mr. Geiger, you have a right to remain silent. Anything you say can't be used against you.
I know.
All right.
I ain't incriminate myself, sir. I was just wondering about my other judge. I have a felony case that I haven't been seen about, and I just been sitting here like since June 13th without no understanding. Like me and my family, we've been communicating, but the funds ain't been right though. So with the funds, I just been sitting here, and then it's a lot of stuff going on that I need to get back to my family so I can help
Okay,
them.
Mr.
It's a possibility that you could contact my other judge on my felony case before he retired. If he retires, I don't know when I might be in court. He's going to retire soon. And
Okay,
he'll-
Mr. Geiger, there's nothing that this court can do regarding your felony charges. You should speak with your counsel there to see if he can assist you or the counsel that you have in the felony matter regarding that. So if you'll speak to your counsel, they will assist you in further hearings in your other case, okay?
Thank you, Your Honor.
Position 22, Hood.
It's going to be a negotiated plea.
Yes, Your Honor, it's going to be negotiated plea, but my client is asking for a NOLO at this time. After speaking with him.
All right, let me find out what's going on. Good morning, Mr. Hood. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have the case heard by video?
Yes, sir.
Can you raise your right hand for me, please? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can put your hand down. Thank you, Mr. Hood. Good morning, Ms. Duncan.
Good morning, Your Honor. Give me 1 second. This is Hood, correct?
Yes, ma'am.
The state's offer in this case is 12 months to serve 60 days, credit for time served, 30 days with the balance suspended. And this defendant is being held on felony charges. This defendant has what appears to be 2 open felony cases, 09 SC 183648, which is disorderly conduct, possession of marijuana with intent to distribute, possession of a controlled substance, possession of a firearm by a convicted felon, and possession of a firearm during the commission. And then there's 22 CP 213636, which is a battery and a false imprisonment against the same victim in the case before the court today. This defendant was given no bond on that case by Judge Oliver on October 3rd, 2022. In this case, the defendant is alleged to have, officers were called to the location because the caller stated that they needed help. However, when officers arrived, the defendant refused to respond to the verbal commands of said officers. SWAT had to be called, and it took a while for them to be able to gain entry into the location and make sure that the victim in that case was okay. That is the basis for the willful obstruction in this case. As I said before, this defendant does have an open battery and false imprisonment with this same victim, Your Honor. So we do have some concern about the risk of reoffense in this case. It is an obstruction, and we are offering time served. We don't see any other no-los, so we would leave that up to the court's discretion.
Let's see. I've been told that he only served 3 days from February 7th until February 9th of this year.
Let me go back and make sure.
I have him, he's been incarcerated, Your Honor, for 28 days. Maybe those days may be included.
Correct. Added with that 3, we got to 30 as of today.
They're not gonna give him credit for time he hasn't served on the case. We had the same issue. Every week, I get a call from the jail and they tell me that we keep giving him credit for time on felony charges and they haven't served the time on the misdemeanor charge. He's holding on 2 felony cases, not this misdemeanor case. This case was placed on the counter because he was in jail. He's not in jail in this case.
Okay, thank you. I'm being told by Mr. Jordan that there's been an issue with the jail as far as when there are felony cases that he's been picked up on and serving time on versus the misdemeanor cases. Apparently, he's only going to get credit for 3 days with regard to this this obstruction charge. So with that in mind, what would you all like to do?
If the court would indulge me for a moment, I want to check something and confer with my supervisor. If we could come back to this case, the state would appreciate it.
I do have 28.
Okay, let's see. I'd rather just hold, Ms. Duncan, to see
Okay.
what your supervisors say regarding this matters so that we don't have to keep shuffling people.
Good morning, Judge. Ms. Duncan, if the issue is the time for the felony as opposed to the misdemeanor, yes, our time is only for the misdemeanor. Apparently, and I don't know the particulars, but I would assume that the defendant was, he's been serving time on the felony case, but he'd made bond on the misdemeanor case, which is why he's not giving credit for time in jail on the misdemeanor case because he'd made bond on that case. Is that my correct assumption? So 3 days is all that he would have served regarding the misdemeanor case, correct?
That's correct, Ms. McCutcheon.
That's what I have.
Yes, because he'd made bond. He just happens to be in custody on the felony case. And so we placed him on this calendar to deal with the misdemeanor charge as well. But he's technically not in custody. He's on bond on his misdemeanor case.
Okay, so as far as this plea goes, is the state amenable to the 3 days time served, credit for time served, or would you all want some other outcome?
What was your initial offer, Ms. Duncan? I'm sorry, I didn't hear it.
The initial offer was 12 months to serve, 60 days, credit for time served, 30 days, with the balance suspended. That 30 days came from that we believed at the time that he was getting credit for the additional time that he was.
Right. No, Your Honor, we do not want to give him credit for the time on the felony case. Our offer is still that he served the 30 days, which on a 2-for-1 would be 12 months to serve 60, but he'd have to serve 30 days, so 27 more days. That would be the state's offer, unless counsel wants to enter a non-negotiated plea. Based on the facts and circumstances, Judge, that is the state's offer on a negotiated plea in this matter.
Your Honor, we aren't going to enter a non-negotiated at this time.
Say it again. I'm sorry, Mr. Ford.
Yes, we are going to enter a non-negotiated. We're going to help wife.
Okay. Thank you, Ms. McCutcheon. Good morning. I
Thank
appreciate
you.
it.
Good morning. Good morning, Judge. I apologize if I did not say good morning when I first.
Oh, no worries, no worries. Ms. Duncan, anything further before I go to Mr. Ford?
As previously stated, Your Honor, the state has some serious concern about the risk of reoffense in this case, given that he does have a subsequent violent and false imprisonment open felony case. And we do have some concern about the particular safety of and danger for this particular victim in general. We were able to make contact, and we did talk to the victim and indicated that she does not want any contact. And so we believe that the state's offer is more than reasonable in this case, given this defendant's history and the circumstances alleged, as well as the ILA factors.
Okay. Well, you keep talking about the victim and the same victim. This is an obstruction of a law enforcement officer. I understand that it might have been that the law enforcement officer was called out to the alleged victim's home, but in this case, it's just the obstruction of a law enforcement officer that he's pleading to. Is that correct, Ms. Duncan?
Yes, in this case, it's the obstruction for a refusal to apply the commands of the officers and letting them inside the home to make sure the victim was okay. So much so that's why he was called.
All right. Thank you, Ms. Duncan. Mr. Ford?
Thank you, Your Honor. Your Honor, even though that my client is getting credit for the 3 days, we still feel it should be balanced. It should be time served, Your Honor, because it's still the time served that he's been there. This took place after the incident. We feel he should get credit for the 28, 30 days that he has been incarcerated. And we ask him for balance suspended as well.
And if I'm correct, defense is making the argument that we just said that was not available to this defendant at this time, which is the credit for the 30 days.
Yes, sir. Even though it's not available, with all due respect to the Assistant Solicitor General, we're asking that he do be given credit because this took place after his the alleged charge. So at this point, Your Honor, we're still asking that he get time served and balance suspended.
All right. I do think that the intent was that he get credit for whatever time that he's been in there and that this is a jail issue. So it's going to be 12 months to serve 6 days, credit for time served 3 days, balance suspended, and I will allow him to use his NOLO. Is he agreeable to that, Mr. Ford? I would imagine that he would be.
Sorry, I'm sorry.
All right, very good. Mr. Hood, it's my understanding that in case 22 CR 000632J, you wish to plead guilty to obstruction of the law, you wish to plead NOLO to an obstruction of a law enforcement officer. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
Yes, I'm mental health. Well, he's. Well, I know what I'm talking about. Yeah. Yes, I agree.
Okay.
Health too.
Whatever medication you're on, it does not hinder your ability to understand what's going on with this court proceeding, does it?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge and that by pleading NOLO to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead NOLO?
No, sir.
I'll accept the NOLO plea as your NOLO plea, Mr. Hood, 12 months to serve, 6 days, credit for time served, 3 days, balance suspended. Good luck to you, sir.
Thank you, sir. Good job.
Thank you said 6 days.
6.
Position 17 and 18, Harris.
And let's see, I have, this is Mr. Murphy's case.
He represents by someone professional stuff. Oh, you're not there? No, I'm not.
That's correct, Judge. I do not see Mr. Murphy on the line at this time. I'll try to reach him and see where he's at.
All right, thank you, Ms. Lewis. Good morning. This is Mr. Murphy's case. He's not with us right now. Can we go to someone else, please?
Position 12, the Brew.
I'm sorry, tell me the position again.
Position 12, the Brew.
Okay, I have position 12 as Geiger.
Guyver. Yeah, I just didn't pronounce it correctly there.
We've already taken position 12. I thought that was a plea.
Oh, you know what? Let me, hold on.
I think it's position 11,
I thought we said that.
Ms. Gabru.
Yeah, it's position 11.
Okay,
I
thank you.
apologize, Judge.
No problem. You're just trying to confuse me this morning. It's not taking much.
What did you say? You did a
All
lot.
right,
This is position 11.
all right. And what's the announcement on position 11? Mr. Ford?
Thank you, Your Honor. Let's see here. I have to talk to Mr. LaRue. Hold on, I got the wrong paperwork. Sorry, I got Geiger. We're on position 11, am I correct?
Yes.
Okay, sorry about that. Yes, Your Honor, this will be a NOLO, and we're requesting time served on this one.
Is it a negotiated NOLO or is you're just asking for a NOLO right now?
Yeah, it's not negotiated, Your Honor, I'm sorry. Because I did get an opportunity to speak with Mr. Gabru last night, and so I just spoke with him this morning. He asked for a NOLO, and that's what we're gonna ask for. He's agreeable with the conditions, but he's asking for a NOLO. So it's not, probably non-negotiated.
Okay. Good morning, Mr. Gabru. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Judge.
Thank you. Can you raise your right hand for me?
Yes, Judge.
Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Judge.
Okay, you can put your hand down. Thank you, sir. Ms. Salette?
Yes, Your Honor. I just want to be clear. So the only thing that the defense is going non-negotiated on is the NOLO.
And the time, jail time.
One moment, Your Honor.
Mr. Howard, while you're doing that, who's from pretrial? Who do I have from pretrial this morning? I'm sorry.
Good morning, Judge.
Good morning, Ms. Harrison. Can you give me the history on position 11, please?
1 second. I'm showing 29 cycles, but he pled NOLO in 2017 for criminal trespass.
Okay. And what other history does he have?
He has a 2020 criminal trespass, which he pled guilty in Gwinnett. He has a, 1 second. Last arrest was on July of this year for a probation violation. Underlying charge was not indicated. And
Bolton,
a, 1 second, checking. He has 4 failure to appear within the past 10 years. He has a 2018 possession of marijuana misdemeanor conviction out of Lawrenceville. Entering auto in Gwinnett, 2017 conviction. Theft by receiving stolen property, also out of Gwinnett. 2016 theft by receiving stolen property, also out of Gwinnett, in which he pled a nolo. 3, failure to appear within the past 10 years. He has a 2016, which he pled nolo for possession of marijuana in DeKalb County. And no additional, I don't see any additional felony, conviction for criminal trespass in the past 10 years.
Okay, thank you, Ms. Harrison. Ms. Saleh.
Your Honor, this criminal trespass occurred at a Best American Inn at 5021 Old National Highway on November 13th, 2022. He has a conviction from August of 2022, criminal trespass and burglary at another hotel off of Old National Highway that he was just placed on probation for in August of this year. He had a probation revocation hearing on October 17th, 2022 of this year, where the judge allowed him to continue on felony probation. And then thereafter, he picked up this current criminal trespass charge off of Old National Highway. Once again, due to his history, him currently being on felony probation and receiving a new criminal trespass charge, the state would argue that he poses a risk of reoffending once again. And so the state's recommendation at this time is going to be 12 months to serve 90 days, credit for time served 13 days, balance probated, stay away from that 5021 Old National Highway in College Park. And there was also some mention in the probation revocation order about him having an MH probation officer. And so the state would also be asking for a mental health evaluation and treatment as well while he's on probation for this case.
What were the facts of the criminal trespass, Ms. Saleh?
One moment, Your Honor. Officers were called out to the hotel because they had asked the defendant to leave numerous times, and he had been previously given a trespass warning at that location on November 5th, 2022. And he was back out again at the location. So he was picked up on November 13th for criminal trespass.
Okay, thank you. Mr. Ford?
Thank you, Your Honor. Your Honor, my client has been incarcerated for 13 days. We're asking for time served. I've spoken with him about the not returning to the incident location. He's definitely in agreement to that. Your Honor, I think based on his history, they said a NOLO was used in 2017. I think the 5 years has elapsed on that because this is the month of late November. So at this point, I feel that he has not played NOLO in the last 5 years. So at this point, Your Honor, we're asking that Mr. Debrew be given time served on this particular incident because it is a criminal trespass situation, and we're asking for a balance suspended as well. We do not believe that that there is a real indication that there's any mental health issue at this time. So we're asking for time served and balance suspended.
And Your Honor, just for the record, the state is objecting to the NOLO, but we'll leave it to the court's discretion since it has been over 5 years since the last NOLO.
I'm not going to allow him to use a NOLO. It'll be 60 days to serve, credit for time served 13, and I do want him to have a mental health evaluation. Does he have a place to stay, Mr. Ford?
Your Honor, my indication from my interview with him that he did give me an address at this time on Charles Allen Drive.
Okay. So that will be court sentence if he is if he wants to plead today.
If the judge is lowered it from 90 to 60, If you take it, you're gonna spend maybe 17 more days to do it, okay? Are you okay with that? No, it's gonna be prorated, because he's gonna want you to do the MOTP, okay? Okay, so the word is. How can you in 60 days? The judge is in 60 days, which based on actual jail days, would be 17 days, okay? You still have to do it. And you have to do a mental health evaluation. But he's gonna have you stay on the probation for the entire 12 months. The ways of food, this time, 17 days to come together. So
Thank you.
you should speak not like this. You don't have any. If you let the judge is already ordered, he said that he can let you.
Hey, Judge, while they decide on what they're gonna do, I have an announcement to make. Position number 5, Mr. Clark, he's downtown. He will be reset for today. He's on the downtown docket.
Okay, thank you.
You're welcome.
He's not gonna do, he's not gonna do it, no, he's not gonna do the time, so, but he says, he do 17 days to get you the mental health value. If you don't, if you don't, you're not gonna do anything.
Mr. Ford, I'm happy to give him the opportunity to think it over. We need to move on to someone else. If he wants to take some time to think it over, I'm happy to give him that opportunity, but I want to move on with the court's calendar.
No, he said he doesn't have any more time to give you.
Position 34, Mr. Persons.
All right, you got it.
No, you're fine, Mr. Ford. I just, who represents position 34? I have that Mr. Banks does. Who's representing Mr. Person? Did we not have the same issue last week with Mr. Person regarding counsel on this matter?
We did, Your Honor. Yesterday, as a courtesy call to the visitation booth, I went to Mr. Person and asked if he had been in contact with Mr. Banks. He said I believe he said his family had tried. Is that correct, Mr. Person?
Yeah, yeah.
The reason we put it in this status last week, and it isn't the status today, is that Mr. Person represents him very definitely an odyssey on his major felony case. And when I went to him last week, he said, he may be incorrect, but he stated that Mr. Person had already appeared on some hearing on the misdemeanor as well. And that he intended to use him for both.
Who said that?
Mr. Person did.
Okay, has anyone spoken to Attorney Banks?
No, Your Honor, I have not spoken to Attorney Banks, and when I looked in Odyssey, I did not see an entry of appearance.
That's correct. There is no entry of appearance.
Okay, so Mr. Person, we have not heard from Mr. Banks. He has not entered an appearance on your behalf. If you would like to have the services of the public defender, I'm happy to allow you to do that this morning. What would you like to do regarding this matter?
We were looking to get the case dismissed, so I mean, any way we could do that.
No, the case won't be dismissed. The state's asking for 12 months to serve, 87 days, credit for time served, 87 days, balance probate at a family violence intervention program, and no further contact with Elizabeth Porter is what the state is asking for a guilty plea, sir.
And Your Honor, if he does use the public defender, our advice to him will be simply put it on a jail jury and talk to Mr. Banks, and it'll all get.
Excuse me.
Ms. Porter, I'll get around to you in a moment, ma'am, if necessary. So, Mr. Person, you have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present at these proceedings. Regarding this matter, if you would like to have the services of the public defender today, I'm happy to give you the opportunity to speak with them regarding moving forward with this matter. Do we know if anyone tried to contact Mr. Banks regarding this?
I tried, last week, I tried one of the two phone numbers I saw and got no answer. I believe it could have been an old number. Mr. Banks's law firm is actually in the same building as our firm, our office on the second floor.
Okay, well, did you leave a message or anything, Mr. McLean? I don't understand why a lawyer wouldn't call the court back regarding a possible client.
Right, I don't know, I do not recall from last week whether I left a voicemail.
All right.
There's a second number, it may be, I'm not sure what that second number is. We can try again right now, Your Honor, and before Costa would find out from his law firm.
Okay, if someone can try to raise Mr. Banks, please, I would appreciate it, whether it's court personnel or you, Mr. McLean, but let's see if we can get in touch with Mr. Banks before we do anything with Mr. Person. All right, so just hold on for us, Mr. Person. Who can we go to now?
Position 11, Mr. Gilbrew.
Your Honor, I spoke with Mr. Gebrew and he's willing to go along with the 60 days and credit for the 13 days. I know he's going to do the mental health evaluation and or treatment. And even though his probation is going to be continued, we ask that the fees be waived at this time because Mr. Gebrew really, he is not employed, has no income.
Okay. Mr. Gabriel, it's my understanding that in case 22 CR 007860J, you wish to plead guilty to criminal trespass, is that correct?
Judge, do you mind if I say something real quick?
Mr. Gabriel, you have a right to remain silent. Anything you say can be used against you. You have an attorney that can speak for you if you like. Quite often people think that what they say to the court might assist in some way, and it does not. So Mr. Ford would like you to address the court, then I'm happy to have you do that.
Thank you, Judge. What is my sentence again?
For a plea of guilty, it'll be 12 months to serve 60 days, credit for time served 13 days, the balance probated, stay away from the Best American Hotel, mental health evaluation. I will waive the fees for you while you're on probation to help you get and stay on your feet, but you'll have to be on probation for the entire 12 months.
So I only have to do 17 more days?
Yes, only 17 more days.
Okay, did I answer your question, Mr. Gabriel?
Yes, Judge.
Okay, and would you like to move forward?
Yes.
Okay, so it's my understanding that you wish to plead guilty to criminal trespass. Is that correct, sir?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as Mr. Gabriel. It's going to be 12 months to serve 60 days, credit for time served 13 days, balance probated, stay away from the Best American Hotel, a mental health evaluation and treatment if necessary. I will waive the fees for you while you're on probation, but you'll have to be on probation for the entire time. Good luck to you, sir.
Your Honor.
Yes, who's speaking?
Your Honor, this is Mr. Person. This is Devin Person's father.
Yes, Mr. Person, good morning.
I was having some complications unmuting the phone when you was asking about Mr. Banks. We had miscommunication on retaining him. we've got that worked out, but unfortunately, he's at another court. He's at a trial today. But we have submitted an affidavit from the victim requesting a dismissal on the case. And we have submitted that at the hearing, but he's pleading not guilty on this.
Okay. So what I am going to, and you're saying that have you retained Mr. Banks at this time, sir? For these charges?
Yes, sir. He is handling the other case, the other case that he's incarcerated for at this time. But the miscommunication on this particular case was, because we thought that everything was going to be dismissed, we submitted the affidavit and requested a dismissal on this case. And unfortunately, we found out just within the last couple of days that this case was going to trial. So we're just asking for a continuance on this so that we can get this understanding on why the trial is not being dismissed, why the case is not being dismissed.
Okay, so what I'm going to do is I'm going to reset this until next week's calendar. What is the calendar for next week's date? December 6th. I'm going to set this for the state all-purpose calendar for next Tuesday, December 6th. Since you've told me that you have spoken with Mr. Banks, would you please let Mr. Banks know that he's going to need to enter a notice of appearance in this matter. At the same time, he is going to have to speak with the solicitor's office regarding this matter and whether or not they are what they're willing to do with the case. I expect that all to be done by next week. So if you can, since you're telling me that you've hired Mr. Banks, if you can let him know that the court intends to see him in this court next Tuesday, December 6th, ready to move forward with the case, okay?
Yes, thank you, Your Honor.
No, thank you, sir. I appreciate you clearing everything up.
Thank you so much.
Okay, thank you.
Your Honor, that's completely consistent with I spoke to Ms.
We're
Banks,
good, man. I had to pull over
and that would be
my
fine.
son's case.
Okay.
We're good.
All right. So I'll see you all next Tuesday. Okay. Where are we now?
Your Honor, this is the South Annex. Good morning.
Good
I
morning.
have a question. On some of the ladies, they have hold for announcement. If those attorneys need to speak to their clients, if they will call and let me know, because I know there's a couple people that have conflict attorneys. And like the one for Miss McLeod, I think it's Miss Malloyd, but I'm not sure. So if they can let me know.
Okay, thank you, Officer Milton. If you all can let the South Annex know if you have clients at the South Annex that you need to speak with, please go ahead and do that as we continue court.
Thank you.
Okay, thank you. Hopefully somebody calls you, Officer Milton.
Judge,
Okay.
this is going to be position number 3, Mr. Bolton.
This is non-negotiated.
That's correct, Your Honor.
All right. Good morning, Mr. Bolton. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir, I do.
Thank you. Can you raise your right hand for me, Mr. Bolton? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir, I do.
Thank you. You can put your hand down. Since this is non-negotiated, let me go to Ms. Harrison first. Ms. Harrison, is there a history on Mr. Bolton?
Yes, Judge, 6 cycles. Last arrest was one moment. Last arrest was January of 2020 for a probation violation in Covington, Georgia. Underlying charge was not indicated. He has a misdemeanor conviction for giving false name. 2, probation violation, a 2019 theft by shoplifting misdemeanor conviction out of Covington as well. And a 2018 battery and a theft by taken out of Newton County. Nothing further to add.
Was that battery a conviction or is it open?
Yes,
It's a conviction?
it's a conviction.
Okay, thank you. Ms. Salet.
And Your Honor, before Ms. Salet speaks, we do have the issue. I spoke to my client again this morning. He's asking for a no-go and to have no further violent contact with the alleged victim.
Well, I'm not going to allow him to use a no-go on this charge, Mr. Ford. And as far as the second request, let me figure out what the facts are before I make a decision on that. Go ahead, Ms. Salet.
Thank you, Your Honor. On July 8th, 2021, Officer Fegan responded to a domestic dispute at 953 Trestle Tree Court and spoke with the victim, Alexis Rowe. That's ALEXUS Rowe, ROWE. Ms. Rowe stated that the defendant entered her home on that day, kicked in her bedroom door, and punched her in the face while she was holding their child. They do have a child together. Officers noticed a visible laceration to the victim's bottom lip. And there was a witness on the scene that witnessed this incident as well. The victim's sister, Opresia Walker, OPREASIA Walker. Due to the defendant having a previous battery conviction, which is a violent charge, and him now getting an additional violent charge as well. The state's recommendation at this time for the criminal trespass and damage to property is 12 months served, 17 days. Credit for time served. Initially, we were going to ask for restitution, but we don't have any documentation for that. So at this time, we will be recommending a time served on that criminal trespass charge. For the battery family violence, 12 months served, 60 days, credit for time served, 17 days, balance probated, 24-week family violence intervention program, no contact with the victim, Alexis Rowe, and stay away from that incident location. And third-party transfer for the child that they share together. And for cruelty to children in the third degree, time served recommendation on that charge, Your Honor.
Has your office spoken with Ms. Rowe?
We have had contact with the victim, Your Honor.
And what was her desire as far as contact?
She said that she would be okay with contact with him. But the state is going to be recommending no contact at this time, Your Honor, due to what we know about the cycle of violence.
Mr. Ford?
Thank you, Your Honor. Your Honor, my client's 24 years old, and before he was incarcerated, he was working at the Ridge Creek Industrial as a machine operator and stock, where he was also stocking and stacking lumber, Your Honor. As has been mentioned, we are requesting no further violent contact due to the fact that they do have children. He does have a child in contact with the alleged victim at this time, Your Honor, and he does help financially, just help support that child as well. He has a stable address. We're asking for time served on this matter, Your Honor, due to the fact that we'd like to see him keep his job. Any more incarceration at this point may put his job in jeopardy, and I don't think that would be good for this particular situation. He will have to pay for class. He's okay with the FDIP, but those classes are somewhat expensive. And so at that point, Your Honor, we are asking that his fees be waived while he's on probation. And after he completes the family violence intervention program, that his probation be terminated at this time. But Your Honor, that job is important to him. His family is important to him. And we do not feel that any jail time, additional jail time would really help this situation. I think it would hinder it somewhat. And so he wants no further violent contact so he can have a smooth transition of seeing his child.
All right, I'm going to accept the state's recommendation with regard to this, except there'll be no further violent contact with Ms. Rowe. But I'll accept the other conditions from the state if he wants to plead guilty.
That is the 60 days, Your Honor?
That's correct.
With the 60 days, you're only going to do 13 more days. And then this lady also and then, Your Honor, he had one question, and after he completes the FVIP, could he go to non-reporting?
Yes, it can go to a non-reporting status when he completes the terms.
Okay, then, Your Honor. He's prepared to move forward, and we do stipulate to the factual basis venue and ID.
All right, thank you. Mr. Bolton, it's my understanding that in case 22 CR 0077773A, you wish to plead guilty to criminal trespass and damage to property, battery, family violence, and cruelty to children in the 3rd degree. Is that correct?
Yes, sir, I do.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, I am.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir, I do.
Has anyone forced or coerced you to plead guilty?
No, sir.
I will accept the plea as I will accept your plea, Mr. Bolton. The terms will be for the criminal trespass, 12 months to serve 17 days, credit for time served 17 days, balance suspended. For the battery, family violence, 12 months to serve 60 days, credit for time served 17 days, balance probated, 24-week family violence intervention program, no further violent contact with Ms. Rowe. And for the cruelty to children in the 3rd, 12 months to serve 17 days, credit for time served 17 days, balance suspended. I'm going to waive the fees for you while you're on probation to help you get and stay on your feet. And when you complete the terms, it'll go to a non-reporting status, okay?
All right. Your Honor, was that no further violent contact?
That was right. Yes, no further violent contact.
So I just wanted to stay away, Your Honor. That's the address where I think you guys live there together? Okay, all right. So.
No, well, no stay away is imposed, just a no further violent contact.
All right, no stay away? All right, thank you, Your Honor. Just wanted to make sure that was clear. All right, thank you.
You're welcome. Who do we have next?
Position 8, Mr. Daniels.
Okay, and this is our negotiated plea.
That's correct, Your Honor.
All right, good morning, Mr. Daniels. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. Daniels. Ms. Salette.
Yes, Your Honor. The state's recommendation for the simple battery is 12 months served, 34 days, credit for time served, 17 days, balance suspended, no contact with the victim in this case, inmate Joseph Woods.
Mr. Ford.
Thank you. We concur with the recommendation of the state. We do stipulate to the factual basis, venue and ID. We're asking that, well, no, that's all, Your Honor. My client, I spoke with, he understands about the no contact with the alleged victim at this time, Joseph Wood.
All right, Mr. Daniels, it's my understanding that in case 22 CR 007761G, you wish to plead guilty to simple battery. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anybody forced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Daniels. Good luck to you, sir.
Good luck to you too, sir.
Thank you.
Position 9, Flores.
This is going to be an arraignment and bond hearing.
That's correct, Your Honor.
Good morning, Mr. Flores. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir. Good morning.
Good morning. Can you raise your right hand for me? Do you swear from the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. Mr. Flores, you've been charged in case 21 CR 0065557J with failure to appear for fingerprintable charge, and in position 10, case number 21 CR 0065557J with possession of marijuana less than an ounce and carrying a weapon without a valid license. Each of these charges carries a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Mr. Ford?
Yes, we do, Your Honor.
How do you plead to these charges, Mr. Flores? Guilty or not guilty?
Not guilty.
Okay. I will record your not guilty plea. Your case will be returned to the division judge, and you will get notification of your next hearing date. Do we have this bond? Ms. Strong, do we have this bond? Is it in the file? Thank you. It appears that on November 18th, he was given a bond for the possession of marijuana and a $2,500 good bond, and on carrying a weapon without a valid license, a $2,500 good bond. What's his history, Ms. Harrison?
He has 8 cycles with history in Georgia and Texas. In Georgia, he has 1 misdemeanor conviction for possession of marijuana less than an ounce out of DeKalb. And Texas, he has a he has a 2008 robbery out of Texas, but no disposition is listed on that arrest. 2016 evading arrest, also out of Texas, and no disposition listed. Nothing further.
Okay. Ms. Lett.
Your Honor, and is this just in reference to the FTA or?
This is in reference to the bond amounts out for the possession of marijuana and the carrying of weapon without a valid license charges.
Yes, Your Honor. On November 17, 2021, officers were dispatched to a gas station at 3843 Jonesboro Road in Atlanta. The officers were dispatched there because the caller stated that there were 2 males standing outside of the gas station drinking alcohol. When officers arrived, they witnessed the defendant buy marijuana from the other male. This defendant was arrested, and upon arrest, he was searched and they found 5 grams of marijuana, a firearm, and a bag strapped to the defendant's chest. And the defendant did not have a permit to carry that firearm at that time. As pretrial stated, the defendant does have history of arrest out of Texas. The last arrest was in 2017. And he does have a 2018 possession of marijuana conviction out of Georgia. The state would argue that he poses a risk of reoffending, and we would ask that you reinstate the $5,000 surety bond that's in place now, the way that is split. Nothing further from the state at this time.
Mr. Ford?
Thank you, Your Honor. My client's 30 years old. He has a very good job working for the construction area at Home Depot. He has 2 children, ages 9 and 11. He has a stable address. He's lived in Georgia for over 5 years. Both of the 2 children are his dependents. He has tremendous community support. I have telephone numbers for his mother, and I think an aunt as well. Your Honor, as we've argued in the past, that the crime that my client is being charged with is no longer a crime. Carrying a concealed weapon or carrying a weapon at this time. So we feel that a signature bond should be in place. He's spent 19 days in jail, and I believe a number of the offenses that were, 2 of the offenses that were mentioned were juvenile offenses. That's where there's no disposition on those at this time, Your Honor. We believe that my client should be able to go back to his job, also to go back and help support his 2 children, and being that the crime that he's being charged with is no longer a crime at this time. And also the state was willing to null pros the possession of marijuana, and also willing to null pros the failure to appear if he was to plead to the carrying the weapons without a valid license, Your Honor. So we feel a signature bond would be in place, would be appropriate at this time, due to the fact that he does not really have a violent criminal history, and the crime that he's being charged with is no longer a crime at this time.
Does he have a bond on a failure to appear?
Your Honor, I have down $5,000, but that might have been a product of the fact that he had 2 $2,500 bonds on the previous charges.
Yes, Judge, there's a bond on the FTA of $5,000.
Okay, thank you.
And Your Honor, my client is stating that he would have come to court. He did not receive notice for the FTA, and he will make sure that that the court has his proper address and contact information.
Okay. I'm going to give you this one opportunity, Mr. Flores, to make good on this. If you don't appear the next time that you should be in court, then I would not do the same thing. But I'm going to convert the good bonds to signature bonds, Mr. Ford, and he's also to have no weapons, drugs, or alcohol while out on bond. If you can prepare those for the court.
Okay, we'll do, Your Honor.
All right, good luck to you, Mr. Flores.
Thank you, sir.
Your Honor, I just wanted to state for the record that even though that there have been some changes in the carrying weapons law, the state is still taking the stand on this case that what he was doing in the manner that he was carrying it is not permitted under the new law as well. Thank you.
You're welcome. So noted, Mr. Lyon. Who do we have next?
Position number 19 on Ford North, Mr. Harris.
I'm sorry, tell me again.
Harris, position number 19.
Hold on.
So this is Devontae Harris. I have hold for announcement. What's the announcement on Mr. Harris?
Your Honor, I didn't get a chance to speak with him. Your Honor, can we move this to a later on in the calendar? I tried to speak with Mr. Harris last night, was not able to do that, and so I'd like to speak with him.
Okay, so can we go ahead and do that, Mr. Ford, if you can, I guess, call for North or however you want to do it?
I'll make sure that happens.
And if we can go back to courtroom 2 and take cases that are not Mr. Ford's cases while he speaks with Mr. Harris, please.
Can we do a breakout session before North, because I don't have a phone up here?
I don't, since Mr. Ford is in courtroom 2, I don't know if a breakout will
Okay, Ms.
assist.
Blunt, I can send I'll have Norris, bring Ford up there.
Okay.
Thank you.
Your Honor,
Yes, Ms. Duncan.
quick announcement from Mr. Person, just for the court's information, I did receive communication from Mr. Banks. He did state to me that he does not represent Mr. Persons. I just wanted the court to be aware of what was just told to me.
Okay, thank you, Ms. Duncan. I appreciate that. Well, we've already put in my next week's calendar, so let's see, Mr. McLean.
I informed him of that as well, but he told me he doesn't represent.
Right. And
Okay,
as I left it with Mr. Banks, I said, if you enter an appearance within the next week, then your name will be on it. Otherwise, our name will be on it. We will be talking with Mr. Person.
okay, thank you, Mr. McLean. I appreciate that.
Mhm.
Who do we have next?
Do we have another? I've got some.
Position.
Please ready.
Position 32, Mr. Owens.
Owens is a not guilty, Your Honor. We only have one Owens on the file.
Good morning, Mr. Owens. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? Can you hear me?
Yes, I can hear you a little bit.
Okay. Do you agree to have your case heard by video?
I don't even know nothing about what's going on. He just came to me yesterday. He was telling me.
Okay, all right. So we'll talk about that in a moment, Mr. Owens. But as far as my question goes, we're doing this by video. Do you mind me talking to you by video this morning?
Oh, yes, sir, Judge.
Okay. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down, Mr. Owens. And as to your question, Mr. Owens, you've been charged in case 22 CR 005961J with battery family violence that allegedly occurred on September 4th of this year. Okay, so that's
September 3rd, and I made bond for it. That's why I was lost. I just got out on bond. I was lost. I was like, I'm in court now.
okay. Apparently, you must have been charged with another felony charge.
No, just battery.
Okay. Have you spoken with him about this, Mr. McLean?
Your Honor, in this case, we have spoken and he is entering a not guilty. We can waive the reading of the accusation because we have a copy and we know what it says. Bond is, for today's purposes, bond on this case would practically be moot. So we just need to be arraigned with the not guilty and put on the jail jury.
All right, so.
And we'll waive the reading.
Judge, it was a bond surrender. That's why he's.
Okay. Okay, I've been told. So it's my understanding, Mr. Owens, that you're going to plead not guilty to this charge. Is that correct?
Yes, sir.
Okay, we'll record your not guilty plea. Your case will be returned to the division judge, and you'll have notification of your next hearing date, sir.
Thank
But
you.
I'm still out on bond on that charge, right?
No.
Apparently, the bond was surrendered, Mr. Owens. So I'm going to give you the opportunity to speak with Mr. McLean at a later date so that he can clarify everything for you. Okay.
Exactly. Thank you.
All right. Thank you, sir. You have a good rest of your day. Who do we have next?
Position 38, Rays.
I could not find Mr. Reyes. I need to speak to him. If we could put him towards the end, I'll get a chance to interview him because he was listed in a certain zone. And when we went to the zone, they said, he's not here. You have to check later. And when we checked later in the afternoon and the evening, there was not sufficient staff to bring anybody out.
Okay, you're fine. Courtroom 2, is it possible that we can take, I see Ms. Watson Cafe on the line. Is it possible we can take her case so that we can release her
Yes,
this morning?
that's fine. Yes, that's fine. Okay. Have a
Good morning, Ms. Watson Cafe.
Morning, Your Honor.
What position do you have?
Positions 1 and 2, Mr. Banks. Where's Banks?
1 and 2, I have that, that's Mr. Lynch's case.
Oh, okay, I thought that
I
was.
believe Ms. Watson Cafe's case is 23 and 24.
Okay, we can do
Yes.
that. Mr. Hooser, positions 23.
And what are we doing with Mr. Hoosier this morning, Ms. Watson Cafe?
We have, I guess, a negotiated plea. Don't have an issue with any of the terms, but if he's eligible for a NOLO, he would like to use that. I don't know the state's position on that. I haven't spoke to them.
Ms. Duncan, any objection to a NOLO on this theft by receiving?
I would have pretrial read the defendant's history.
Ms. Harrison?
I'm checking now, Judge, one moment.
While you do that, let me just address Mr. Hoosier. Good morning, Mr. Hoosier. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yeah.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yeah.
Okay, thank you, sir. You can put your hand down. Just let us know when you're ready, Ms. Harrison.
You just want me to check for NOLO, correct?
Or theft by any type of theft charges, if you would.
I would like you to read the history that you have.
He has 8 cycles. Last arrest was identity theft fraud. And he has an open case pending, felony 22 CP 213636, false imprisonment and battery. And he has a 2021 arrest for burglary in the 2nd degree, theft by taking, criminal trespass in Fulton County. No disposition listed on that. Then he has an additional theft by receiving stolen property, criminal trespass in 2021. And a theft by shoplifting in Fulton County. No disposition listed on that. A theft by shoplifting 2015, that was a conviction. And a 2000 burglary, no disposition.
All right, thank you. Thank you, Ms. Harrison. I'm not going to allow him to use a NOLO. If he wants to plead guilty, the court will accept a guilty plea.
I believe when I spoke to him, he said that would be fine. Mr. Hoosier, is that still your position?
Yes.
Okay. We can move forward, Your Honor.
Okay. Ms. Duncan?
Yes, Your Honor. In this case, the defendant on August 16, 2021 reported that a storage unit that he was renting had been burglarized. However, the defendant was later on camera with a U-Haul taking items out of said storage unit. And in this case, we are concerned about the risk of reoffending. This case was originally a felony case. However, the Superior Court sent it back to us. This defendant does have an extensive theft history. However, in this case, the state is amenable. We were trying to, given the information that was presented to us by the jail as far as the 2-for-1s and the availability of credit for time served, we were trying to verify the amount of time that this defendant had served. We were under the impression that the amount of time served was either 200 200 or 375 days. However, that is in addition to the initial 17 days for the initial arrest. So our offer originally to Ms. Watson Cafe and her client was 12 months to serve, 200 days, credit for time served, 200 days with the balance suspended. However, if the defendant has not received credit for 200 days on this offense, the state is trying to gain clarity on what our offer would be at this time.
We know how long he's been in on this charge.
I can't even see any jail time. I must have came in as a fine over 8/16/21.
On a previous arrest, Judge, he was in jail for 17 days on this charge.
Yeah, it was.
Okay, so is the state amenable to 12 months to serve 17 days, credit for time served 17 days?
At this time, I would like to clarify with my supervisor. It was my impression that we were not okay with the 17 days, given this defendant's history. If the court would give us some indulgence, I would communicate with my supervisor just to be sure on what the offer is, since it's not anywhere near that 200 days that we thought this defendant had served for this offense.
So again, Ms. Duncan, is it our calculation was incorrect? What was
Yes.
our initial offer to the defendant?
Our initial offer was 200 days. We believed that he was getting credit for the rearrest. However, as we've been notified today, since he picked up additional charges, that he's not getting credit for that. He's only gotten credit for 17 days.
Well, Judge, I heard the court's ruling on the previous case. Since it seems that the calculation of the days was an error on the state's part, which is why I guess in the future we should just defer to the jail and just announce credit for time served and let the jail figure out what that time is so that the state does not become involved with that and subject to making a mistake. So I'd recommend 30 days, Ms. Duncan, if the state recommends 30 days, which would be, well, actually, if we recommend 35 days, it seems like he's going to be getting credit for the 17 days. Recommend 35 days to serve, since the error appears to have been on the state's part as far as the calculation of the jail time.
And I think the intent was, correct me if I'm wrong, is that this was to be a time served and that the calculations of the time is because of the jail. That's what's off.
The calculation of the time served was keeping in mind that the defendant's history, and we thought that the amount of time served was significant given his significant history with thefts. That was the state's process when.
Okay, so I guess on these cases where they picked up other charges and are not getting credit for the actual misdemeanor, if we could just look into that a bit more before the offers go out. This is the first time I know that this has come up as an issue, so I understand the state's where the state is with this. Can we all agree, possibly, since he's got credit for time served, 12 months to serve, 34 days, credit for time served, 17 days, since that'll be add up to 34, balance suspended. Is that agreeable with everyone?
Yes, Your Honor.
That's agreeable, Judge. And my apologies, Judge. As I say, I cannot count. I said 35. I should have said 34 days. 17 is half of 34. Thank you, Your Honor.
You're fine, Ms. McCutcheon. Ms. Watson Cafe, is that fine with you?
It is. And Mr. Hoosier, do you understand what has happened? The result would be the same. It's just that there's a difference in the way that the days are being calculated, but the result would be still a time served offer. Do you understand that?
Okay, yeah.
Okay, you still want to move forward? Okay.
All right, thank you all. So if nothing further, can I go ahead with the plea? Okay, Mr. Hoosier, it's my understanding that in case 22 CR 003818G, you wish to plead guilty to theft by receiving stolen property. Is that correct?
Yeah.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury? Has anyone forced or coerced you to plead guilty?
No.
Okay, I'll accept your plea of guilty, Mr. Hoosier. 12 months to serve, 17 days, credit for time served, 17 days, balance suspended. Good luck to you, sir. Okay. And I believe that position 24 is Ms. Watson Cafes also. Is that where we're going
Yes,
next?
and that's also a negotiated.
Okay,
And I have position 37, which is for Watson Cafe.
okay.
I'm sorry, position 24.
You got me nervous.
Sorry.
And this is Ms. Hunter, is that right?
Yes.
Good morning.
Yes.
Ms. Hunter. Good morning, Ms. Hunter. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me, ma'am? Do you swear the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, ma'am. You can put your hand down. Ms. Duncan?
The state's offer in this case for count 1, battery family violence, is 12 months to serve, 90 days, credit for time served, 24 days. That's an additional 21 days from today. With the balance probated, a family violence intervention course, no further contact with the victim in this case, stay away from the incident location. For count 2, the state's offer is 12 months to serve, 48 days, credit for time served, 24 days with the balance probated in a parenting class. For count 3, the offer is 12 months to serve, 48 days, credit for time served, with the balance probated in 40 hours of community service, and they are to run concurrent.
Ms. Watson Cafe?
We would just ask that the offer, Your Honor, I'm sorry, Your Honor. We would just ask that Your Honor accept the offer as negotiated. I've spoken to Ms. Hunter, and she's wanting to move forward with the case, the plea as negotiated.
Ms. Hunter, it's my understanding that in case 21 CR 004515F, you wish to plead guilty to battery family violence and 2 counts of cruelty to children in the 3rd degree. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with her representation?
Yes.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yeah, I understand.
Is anybody forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated. Ms. Hunter, I am going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And when you complete the terms, it'll go to a non-reporting status, okay?
Okay.
Your Honor, I just apologize. I should have said something earlier. With respect to the this case involves the father of the 2 children. As far as the no contact order, I just wanted to make it clear that they can have a third party transfer with respect to the kids. The children stay with Ms. Hunter, but the alleged victim in this case is the father of the children. He has weekend visits with those children.
Okay, of course. I would not keep any child from their parents, so there can be third-party transfer of the child for visitation. You'll have to arrange that through someone else, Ms. Hunter, as you are not to have any contact with the victim in the case. Okay, but you'll have to get someone else to arrange that contact. All right.
All right.
All right. Good luck to you, Ms. Hunter.
Just to go back to position number 19, Mr. Harris.
May I be excused, Your Honor?
Yes. Good to see you, Ms. Watson Cafe.
Good to see you as well. Thank you.
All right, so this is position 19, is that correct?
Yes, sir, Devontae Harris.
Okay. What's the announcement?
It's a negotiated plea, Your Honor.
Okay, very good, thank you. Good morning, Mr. Harris. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, sir. Ms. Salette.
Your Honor, the state's recommendation for the simple battery family violence is 12 months served, 30 days, credit for time served, 4 days, balance probated, 24-week family violence intervention program, no contact with the victim, Deasia Coleman, Deasia Coleman. Stay away from the incident location, which is 1523 Fairburn Road, and third-party transfer for the child that they share.
Mr. Ford.
Thank you, Your Honor. I spoke with my client and we concur with the state's recommendation, and we do stipulate to the factual basis, venue, and ID.
Mr. Harris, it's my understanding that in case 22 CR 002913J, you wish to plead guilty to simple battery family violence. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated. Mr. Harris, I am going to waive the probation fees for you while you're on probation to help you get and stay on your feet. And when you complete the terms, it'll go to a non-reporting status, okay?
You understand?
All right. Good luck to you, sir.
Thank you, Your Honor.
You're welcome. Who do we have next?
Position 6, Mr. Cochran. No, you good. Yes, sir.
This is going to be an arraignment and a bond hearing.
That's correct, Your Honor.
Can you pull that bond for me? Good morning, Mr. Cochran.
Good morning, sir.
I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, sir. Mr. Cochran, you've been charged in case 22 CR 003611A with simple battery. This case carries a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. Ford?
Yes, we do, Your Honor.
How do you plead, Mr. Cochran, guilty or not guilty?
Guilty, sir.
It's my understanding that you were going to plead not guilty this morning, Mr.
Your
Cochran.
Honor, I'm going to enter a not guilty plea for my client.
Not guilty, sir.
We'll record your not guilty plea. Your case will be returned to the division judge, and you'll get notification of your next hearing date. Do we know what the current bond is?
I didn't see one, Your Honor. That's why.
Okay.
He's not being held in jail for this charge, Judge. He was in front of Judge Roth, and I guess they never issue out a warrant on any on his case. It was just that he just been scheduled from the judge, and really there's no FTA on this case, and there's no bond amount. I think it was a bind over case, but he's not being held in jail for it.
Okay, regardless, I think that we have to have some type of bond for him on this matter, correct?
I'll look and see, but it was a bind over from another municipality.
He has an open felony case, 22 CP 212245, for an aggravated, it's a CWAT charge and cruelty to children 3rd degree, and another CWAT charge.
Okay, and is he on no bond on those charges?
One moment. I'm not sure, Judge. I'm not seeing the bond.
Your Honor, I'm seeing that he has no bond on those. None have been set.
That so you're telling me that he has a bond and that, but it's no bond.
No, it says not set, Your Honor. I apologize. It says not set. That's why it says no bond on all his felony charges.
Okay, well, just out of an abundance of caution, let's go ahead and set a bond on this simple battery case. Ms. Let, what's your recommendation?
Yes, Your Honor. On May 18th, 2021, officers were dispatched to 5401 Old National Highway, apartment 1309. Officers came in contact with a Miss Vanika Ellis, that's Vanika, who was the mother of the victim in this case. The victim's name is Julian Ellis, who is her 13-year-old son. She advised that her boyfriend, the defendant, had come to their residence. He was drunk and being belligerent, and he pushed the 13-year-old son against a drawer. There were no visible injuries. The defendant does have a prior simple battery family violence arrest from 2021 with the same 13-year-old son being the victim in that case as well. That incident happened in August of 2021. Two incidents occurred maybe about, I guess, 3 or 4 months apart with the same victim. The defendant has a 2020 aggravated assault arrest, 2012 battery arrest, 2010 aggravated stalking. I'm also showing a 2003 aggravated assault with the intent to commit a CWAC crime conviction. That's from 2003, and a 2009 FTA conviction. Also, that felony open case that he has, the CWAC charges, the 11-year-old victim in that case has the last name of Ellis. And I'm just going based off of the warrants that person may have a relation to the victim and the mother in this case as well. Due to the defendant's violent history, his history with the same victim, the state's recommendation at this time is going to be a $10,000 surety bond. And due to him having an FTA conviction as well, the state would argue that he poses a risk of reoffending. Nothing further from the state at this time.
Stay away and no further contact?
Yes, that's correct, Your Honor. No drugs or alcohol or weapons as well.
Where is the stay away from?
The stay away is from 5401 Old National Highway, apartment 1309.
Mr. Ford?
My client is 38 years old. He is a high school graduate. He's been in Georgia his entire life. And my client was working 3 jobs, Your Honor, before he was incarcerated. He's working at Taco Bell, Popeyes, and at Walmart, so he was very employable. He has 8 children, Your Honor, and 4 boys, 4 girls, where he was working those jobs because he was providing financial support for those children. 2 are his dependents. He has community support. I have a telephone number for his mother. I also have a stable address for him, Your Honor. As you note that some charges were quite dated at this time, Your Honor. So I would ask that that he receive a signature bond. He has done 90 days, I think 80 days in jail, Your Honor. We're asking for a signature bond on these cases, or if minimum, nothing more than a $1,000 surety bond.
All right, so Mr. Ford, it's going to be a $5,000 good bond. No further contact with the alleged victims. Stay away from the Old National Highway address, and no drugs, alcohol, weapons while out on bond. All right, good luck to you, Mr. Cochran.
Thank you, Your Honor.
Yes, sir. So what, I got, what is the bond?
Who do we have next?
Position 33. Mr. Palomino.
This is going to be a negotiated plea.
It is.
Good morning, Mr. Palomino. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you really have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court to be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you. Ms. Duncan?
Yes, Your Honor. In this case, the state's offer is 12 months to serve, 32 days, credit for time served of 16 days, but the balance is suspended.
Mr. McLean?
Your Honor, the defendant asked the court to accept his negotiated plea of guilty and will not be fooling any more fire alarms.
Mr. Palomino, it's my understanding that in case 22 CR 007783E, you wish to plead guilty to transmitting false report of fire. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand you have a right to a trial by jury on this charge, and if by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, sir. Good luck to you.
Thank you, Your Honor.
You're welcome.
Position 17 and 18, Harris. Hold on, let me see. Is this Mr. Lynch case?
Yeah, this is Mr. Murphy. Mr. Murphy, join us. I know that I got a note that he was going to join us.
Yeah, he's on there.
Can't talk to him.
Mr. Murphy?
Murphy's is not on the line. He's supposed to be coming in person in the courtroom, Judge.
Okay, thank you. Can we take someone else while we still await Mr. Murphy?
I have a couple of new announcements, Your Honor, on things to be announced.
Okay, Mr. McLean.
Mr. Tanner is the time served balance suspended plea. It's a negotiated plea and he is ready.
You're gonna have to tell me the number.
A time served, I'm sorry. You said you don't have to.
What number is he on the calendar?
Tanner's towards the very last page. I believe he might be 40.
Okay. And what's the announcement on Mr. Tanner?
It is a negotiated plea of guilty.
Okay.
Also, Mr. Jean-Pierre. Same announcement. Jean-Pierre, same announcement is number
26.
26.
So where do we want to go now? Who's ready?
Can we do positions 1 and 2, Mr. Banks?
Mr. Lynch, are you ready for Mr. Banks?
Yes, Your Honor, I do represent Mr. Banks. Your Honor, today we will be entering pleas of not guilty for each case. If you'd like me to submit a waiver of formal arraignment, I can do that very shortly.
Okay, if you'll submit a waiver to us, we'll get that entered. Okay, so we don't need to see Mr. Banks. His attorney submitted a waiver of arraignment.
So he's completed, he's done.
Yes, he's done. Good luck to you, Mr. Banks.
Position 25, Jackson.
Your Honor, on Mr. Jackson's case, we are trying to get a document to Ian Walker. Hi, Mr. Walker.
Ms. McCutcheon is supervising today.
Okay. It would be Michelle.McCutcheon at FultonCountyGov, right?
That's correct, Mr. McLean.
Okay. And and Michelle is the regular spelling.
With one L, Mr. McLean.
It's Ellie at the end instead of 2 L's. So
Correct.
Deputy Norris is going to try to send you a death certificate of the alleged victim in the case, whose name was Mr. Bowser. He was the former spouse. Before he died, apparently they separated or divorced. The other co-defendant, Deborah Jackson, is the aunt of the defendant here today. Her case was dismissed in the past. He tells me, I've not confirmed this because the only sheet of paper I have in court today is just the Odyssey face sheet summary. But in talking to him, he said, if you'll get hold of my relatives, they can call their relatives, get a death certificate and send it to you. Apparently he died after having divorced or separated from Deborah Jackson, the aunt. The aunt apparently was, although I have not confirmed this on Odyssey, the aunt apparently was also charged with the pushing and shoving incident, and her case was dismissed. I imagine the reason for her dismissal was the death of the alleged victim.
Is this an algorithm, Mr. McLean? Respectfully, I'll have to write this down. What number, what position?
I was like, did you get all that, Ms. McCutcheon?
Let's see.
I'm trying. I'll try to review it and get as much
Sure.
insight into this as I could, Mr. McLean. I must admit, I'm
Absolutely.
quite surprised. If you'll send me your document, and what number is this on the calendar, please, sir?
Mr. Jackson is number, let's see,
25.
25.
25. Thank
That's
you.
07 case, Ms. McCutcheon.
I'm sorry?
That's the 07 case.
That's the 07 case that you and I communicated about this morning. All right, thank you, Judge. I'll look at it. Thank you, Mr.
Okay.
McLean.
It's a really old case. Thank you. Thank you.
All right, so who can we go to now while that's being reviewed?
Additional announcement, Mr. Martin Reyes is also a negotiated plea of guilty.
Okay,
Positions 30 and 31, Mr. Mendoza.
He is a negotiated plea of guilty. I had a bit of confusion. Mr. Mendoza has 3 positions on the calendar, and the FTA on a court day alleged is the 3rd case. Is there a global resolution where we can take care of that matter today? But we are pleading guilty to the other 2 cases.
The offer is as communicated. We have specific offers for the 28 and 29 and for the FTA. As communicated, we will request that this court send that case back to Judge Taylor for a bond modification, since that is the court in which the defendant FTA'd.
well, I mean, in something like this, if he's going to enter a plea to these charges, why can't we just deal with the FTA today so that this doesn't, so that he can be done?
It's generally the court's practice. So that's what we were
It is
recommending.
if a plea is not being entered, it's the court's practice. But given that pleas are being entered and the FTA is for the pleas that are being entered, doesn't it make more sense just to deal with everything now?
The offer is additional time. So I guess we could, if Your Honor would like, I would need additional time to pull that information up. Our Odyssey is still experiencing technical difficulties, but we can go ahead with the offers for positions 29 and 30.
And we're prepared to do that. We're just hopeful that the other FTA could be globally thought of and resolved.
And Your Honor, on behalf of the state, I do agree, Ms. Duncan, we should take care of as much as we can. It's much more efficient before the court today. So if the defendant is going to enter a plea, then we can take care of the FTA as well today so that all the matters are closed.
Thank you.
Understood.
I understand that he has additional time on the other 2 cases for this FTA. Would it be satisfactory if we gave him 32 days credit for time served, 32 days?
It's not crucial, Your Honor. He has a hold, but a few days this way or that way is not going to make a difference to that hold, but he just needs to get to his hold at a reasonable time. So
No, I'm just trying to come to a resolution on position 31, a failure to appear.
Right.
So if you all can come to an agreement on what's satisfactory with that charge, the court was simply suggesting 32 days credit for time served, 32 days balance suspended.
That works for the defense.
Okay, I'll have to take a look at it, Your Honor. Can we come back to that in just a
Let's do it.
moment?
Let's do it right now. Take a look at it.
Okay.
Yes, ma'am. All right, I love you.
We can hear you, Mr. Lynch.
Yeah. Judge, this is Miss Lewis. If they're trying to figure out the time on, he's been in jail for the FTA for 33 days and position number 29, he's not being held in jail for that. He's been in jail for 5 days on a previous arrest for that. And the position 30, he's been in jail for 33 days. Hopefully I can share a little light on something.
The 32 days should be sufficient for the FTA. However, I just want to make it known to the court that this defendant was on a $4,000 cash bond, if I'm not mistaken. He does have somewhat of a violent history, and this would includes battery family violence. However, since this is just an FTA for failure to appear, since the defendant is before the court at this time, I believe if Mr. McCutcheon does not object, the 32 days will be sufficient to satisfy that matter.
Okay, very good. Thank you, Ms. Duncan. Okay, Mr. Mendoza, good morning. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, thank you, sir. You can put your hand down. Ms. Duncan, would you start with position number 29, and then we'll go to 30 and then 31.
Okay. And I just would like to add my apologies that the FTA, because he did miss arraignment before Judge Taylor on October 3rd, 2022.
Okay.
I'll start with position 29. The offer is global for this case ending in 969H, 12 months to serve, 120 days, credit for time served with the balance probated. There was restitution, however, we don't have that documentation, so we'll dispense with that at this time. And we're asking for a stay away at 1185 Collier Drive in Atlanta. And we would like that to run concurrent with the next position.
Okay.
And for the next position, ending in 425H, the state's recommendation for the battery family violence is 12 months to serve, 120 days, credit for time served, 32 days with the balance probated, and family violence intervention course, no contact with Maria Garcia, that's both common spelling, and stay away from the victim's job, and 1185 Collier Drive in Atlanta.
Okay.
And on the failure to appear, ending in 016, the state is amenable to 12 months to serve, 32 days, credit for time served, 32 days with the balance suspended.
All right. Thank you, Ms. Duncan. Ms. McLean?
That is the understanding of the defense, and we ask the court to accept that, and we stipulate to the 3 elements.
Mr. Mendoza, it's my understanding that in case 22 CR 004969H, you wish to plead guilty to criminal trespass, giving false name, address, or birth date to law enforcement officer, and willful obstruction of law enforcement officers. In position 30, case number 22 CR 007425H, you wish to plead guilty to battery family violence. And in case 22 FTA 000016, you wish to plead guilty to failure to appear for a fingerprintable charge. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
I understand, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I will accept the guilty pleas as negotiated, Mr. Mendoza. I am going to waive the probation fees for you while you're on probation, but you're going to be required to be on probation for the entire time, okay? All right, good luck to you, Mr. Mendoza.
Thank you, Your Honor.
Position 39, Smiley.
And after position 39, Your Honor, may we do position 36?
Okay,
Thank you.
and Mr. Smiley's a negotiated plea, is that correct?
Correct.
Good morning, Mr. Smiley. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Can you raise your right hand for me, sir?
Yes,
Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, thank you, sir. Ms. Duncan?
Yes, Your Honor, the state's recommendation in this case ending in 763D is 12 months to serve, 32 days credit for time served, with the balance suspended and a stay away from all MARTA. The state would like the court to know that this defendant does have a current full year suspension from MARTA facilities.
Ms. McLean?
Your Honor, he will accede to, he agrees to, and he will obey the suspension for MARTA facilities for a 12-month period, which I believe begins. It started in January. I think it's for calendar 22. Is that correct? Calendar year 22 is the 12 months MARTA suspension, all facilities, buses, trains, stations.
So he's gonna have to abide by any MARTA suspensions, active suspensions.
Correct, and that's his understanding. If that's the state's understanding what the suspension is that he can't get on MARTA until January 1st upcoming. And he pleads guilty and asks the court to accept his negotiated plea.
Well, he's gonna have to make sure that, Mr. McLean, that I'm gonna say that he's gotta abide by any active MARTA suspensions. I don't know what those MARTA suspensions are. If you tell me it's January 1st of 2023, I'll accept that. But if it's not, if it's some other date, you're gonna have to make sure that your client abides by whatever the active MARTA suspensions will be.
I will discuss that with him, Your Honor. I haven't seen any documentation of it, just his current understanding of it.
Okay, all right.
Thank you.
So, Mr. Smiley, it's my understanding that in case 22 CR 007763D, you wish to plead guilty to certain acts on a bus, rail station prohibited and criminal trespass. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, are you giving up your right to a trial by jury?
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept your plea as negotiated, Mr. Smiley. Understand that you can't go back to MARTA until your suspensions have been lifted, okay? So make sure that they've been lifted before you go back there.
Yes, sir.
And Your Honor, to clarify for the court, the warrant does indicate that it is a full year suspension. However, it does not indicate a start on an end date.
Okay, thank you, Ms. Dunn.
Understood.
All right, who do we have next? South Annex? All right, tell me again. Officer Milton.
Oh, I'm sorry, position 2036, Ms. Clark,
Position.
3636.
All right, thank you. What's the announcement on Ms. Cost?
Judge, that's going to be an arraignment and bond hearing.
All right, good morning, Mr. Howard.
Good morning, Judge.
Good morning, Ms. Cost. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
All right. I'm sorry, I can't hear. Someone is.
Yes, sir.
Okay, thank you, Ms. Cost. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
All right, you can put your hand down. Ms. Potts, you've been charged in case 20 CR 000755F with failure to maintain lane or improper lane change. divided highway controlled access road violation, possession of open alcohol container, reckless driving, and driving under the influence of alcohol less safe. Each of these charges carries a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. Howard?
We do, Judge. She has copies.
How do you plead, Ms. Potts, guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. What are the current bonds in the matter?
Judge, it's 1,000 on the fade and maintain lane, the divided highway, open container, and reckless driving. And then there's a $2,000 bond on the DUI.
So $6,000 bond
Yes.
total?
Yes, Judge.
Okay. Ms. Duncan?
Yes, and the state would like to note for the record in this case that the defendant did fail to appear in this case for plea and arraignment back in May of 2023. And this the reckless driving and DUI in this case did result in a motor vehicle collision. And this defendant does have some criminal history. So in this case, the state believes that the bonds as previously set on this case are more than reasonable. In addition to these charges, the defendant does have a speeding from 2011 citation, a failure to yield the right-of-way citation, and a school suspension on the driver's history. In addition to that, this defendant does have 5 cycles that include convictions for criminal trespass and other offenses, Your Honor. Given the reckless nature of what occurred in this offense and the dangerous nature that is involved in driving while under the influence, as well as recklessly driving to the point where a collision occurred, the state believes that those bonds, as previously said, are more than reasonable, and we would ask that they remain.
Mr. Howard?
Yes, Judge. And in this case, Ms. Potts posted bond on this. And Judge, she missed court on May the 23rd. However, she was in custody in Clayton County. I was able to confirm with Clayton County Jail this morning that she was in custody with them from March the 12th of 2022 until October the 7th of 2022, at which time she was transferred to Fayette County from October 7th to 11/15 of 22. And then she's been here since 11/15/22. So essentially, she's been in continuous custody since March, Judge, which is why she missed the court date. And I believe on Odyssey, there's a proof of incarceration link that unfortunately none of us has been able to open, but I was able to confirm with both facilities this morning that she has been in custody since those dates. So we would ask that the bond be reinstated or that she be given a signature bond, given that she could not comply with showing the court if she was in custody, Judge.
Okay. Given that she was in custody, I'll reinstate the previous bonds, Mr. Howard.
All right. Thank you.
Okay. Good luck to you, Ms. Potts.
Thank you. So that means I will get the signature bond, the remaining bonds.
Your bond's going to be reinstated, so you'll be released again on the bond that you originally posted.
Okay, thank you so much. I have a great day.
All right, you're welcome.
Position 27, Johnson.
He can send it to us, because if we don't send it to the jail don't know.
Okay, give me 1 second.
I can't find that bond.
Mr. Howard.
Yes.
Mr. Jordan is telling me that, do you have that bond order? Yes, find it, so.
Yes. So I need to, okay, he needs the bond order.
Yes.
Yes.
It was a bond cover case, so we never got.
Apparently this was a bind over case and we never got the original bond. So what do we need, Mr. Jordan?
Yeah, what do we need?
So they're saying, because you had released on the original bond, but
Okay.
the jail doesn't have anything to release. So
Okay.
they're gonna ask me for the original bond.
All right, so what I'm gonna do is this. Since it was a bond over, let's convert the good bonds to signature bonds. And
Okay,
that
and I'll
should-
submit that order, Judge.
Okay, and that should take no drugs, alcohol, weapons while out on bond also.
Okay,
That'll take
I'll
care of
submit
it.
that order.
That should take care of it, Mr. Jordan?
Yes, sir.
Okay, all right. Understood, Mr. Howard?
I said I'll submit that order to Ms. Strong.
Okay, thank you. Who do we have next?
Position 27, Johnson.
We can fix Mr. Lynch.
It says it's yours on the paper.
Mr. Lynch, what are we doing?
For Mr. Sonny Johnson, Your Honor, we do have a negotiated plea.
Okay, very good. Good morning, Mr. Johnson. I'm Judge Eric Morrow. This is the state all purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you. Let's see, Ms. Duncan.
Yes, Your Honor. In this case, the state's offer is 12 months to serve, 45 days, credit for time served, 17 days. That's an additional 5 days with the balance probated, a 6-week anger management course, and no further contact with Richard Abernathy.
Mr. Lynch.
Yes, Your Honor, that was the understanding of the offer from the state. I was going to ask Your Honor to consider waiving probation fees in his case. Mr. Johnson does not have any formal employment at this time. He has struggled with homelessness, although he does have a steady address where he can go, I'm told, at this point. So we would ask the court to consider waiving probation fees. And I'm not sure whether Your Honor would consider allowing him to go on a non-reporting status once he completes all the conditions of probation.
This defendant does have a recent violent conviction from June of 2021 for battery family violence and does have an open felony case 21 CP 200223 for possession of MDMA and theft by shoplifting. This defendant also has at least 3 probation violations in his history that has a total of 11 cycles. So the state would be opposed to that, but we would defer to the court.
So I'll waive the fees, Mr. Lynch, but he's gonna have to be in probation for the entire time. Okay?
Your Honor.
All right, Mr. Johnson, it's my understanding that in case 22 CR 007765Y, you wish to plead guilty to battery, is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Johnson. I'm gonna waive the fees for you while you're on probation to help you get and stay on your feet, but you're gonna have to be on probation for the entire time, okay?
Yes, sir.
All right, good luck to you, sir.
Your Honor, may I ask before we have him, because I need to get his contact information to probation, if there's any way he could get the deputy to put a good phone number for him in the chat, because I don't think he had a good phone number when I last interviewed him.
I got it down in my cell. It's my fiance's phone number. I don't know it by heart, but it's put down in my Bible.
All right.
I got it myself, but if I can get it,
All right,
you can give it to the officer.
All right, I'll follow up. Sorry about that.
All right.
All right, thank you.
Do 5 extra days. So I can do extra 5 extra days, is that what we're saying?
What's the
question? I gotta do an extra 5 more days, right?
That's correct. I believe you have credit for 17 days and there's 5 days additional, but by my calculation.
All right.
All right.
Position 26, Genity.
That's a negotiated plea, Your Honor.
Okay.
This, I believe, is 2 counts, obstruction and trespass, and a stay away from a gas station.
All right, good morning, Mr. Genety. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Put your hand down. Thank you, sir. Ms. Duncan?
Yes, Your Honor, the state's recommendation in this case ending in 775G. For both counts, it's 12 months to serve, 34 days, credit for time served, 17 days, with the balance suspended and a stay away from the Exxon gas station located at 1105 Holcomb Bridge Road in Roswell.
Ms. McLean?
Your Honor, we've discussed all those rights on the plea sheet, and he wishes to ask the court to accept his negotiated plea of guilty. He stipulates to the plea elements, ID, venue, and factual basis, and he will abide by the stay away.
Mr. Genety, it's my understanding in case 22 CR 007775G, you wish to plead guilty to willful obstruction of law enforcement officers and criminal trespass. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning? No. You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you've given up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Genety. Good luck to you, sir.
Good night.
Your Honor, we have before you position 37, Ms. Reese.
That'll be my case, Your Honor.
And this is going to be an arraignment?
Correct. We waived the reading of the accusation. She pleads not guilty, and we asked to go to a jail jury calendar. Bond is practically moot at this time because of the situation.
Good morning, Ms. Reese. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're doing by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down, ma'am. Thank you. Ms. Reese, you've been charged in case 22 CR 004354J with simple battery of family violence. This charge carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Mr. McLean?
We do.
How do you plead, Ms. Reese? Guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge, and you'll get notification of your next hearing date. Good luck to you, ma'am.
Thank you.
Thank you.
Have a seat over there. Your Honor, can we do position number 4, Ms. Brown?
Okay. Is this, Ms. McLean, Ms. McLeod, good morning. Is this your case?
Good morning. It is, Your Honor.
What are we doing, Ms. Brown, today?
It's going to be an arraignment, Your Honor, and also I would like to bring a motion to modify her bond.
Okay. Good morning, Ms. Brown. I'm Judge Eric Morrow. This is the state all-purpose calendar.
Good morning.
Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear that the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You can put your hand down. Ms. Brown, you've been charged in case 22 CR 007530 with battery family violence. This charge carries a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Ms. McLeod?
I do, Your Honor.
How do you plead, Ms. Brown? Guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge, and you'll get notification of your next hearing date. Do we have her bond? Thank you. Let's see. Ms. Brown received a $2,500 good bond back in November 3rd. Are there some changes of circumstance, Ms. McLeod?
Well, she has not been able to make that bond, Your Honor. She doesn't have anyone to help her. And also the cross defendant, Your Honor, is also incarcerated. My client doesn't have anyone here in Atlanta to help her to make bond. That's why she's been sitting in jail since her first appearance.
What is her history, Ms. Harrison?
9 cycles, last arrest, April of this year for theft by taking in Fulton County. Record does indicate the defendant is currently on probation for robbery and aggravated assault in Fulton County, 20 SC 175834. Sentenced December of 2020, 10 years probation. I'm sorry, it's 2 years to serve and 8 years probation, total of 10 years. Additional open probation for theft by taking, 22 CR, well, one moment. 22 CR 00227-4A, sentenced July of this year.
What was that? What was she sent? What was the charge?
Theft by taking. And was sentenced to, it was a NOLO plea. Sentence was not listed, it just says a NOLO plea.
Okay.
And that's it, Judge.
Your Honor, at the time of her first appearance, I did raise some issues. My client was injured in this, she was not the primary aggressor, she told me, and she was injured, she had to be treated. I believe she had to go to the hospital. That's my recollection. And she asserted that she was not the primary aggressor in all of this.
Ms. Select?
And Your Honor, the state would argue that the $2,500 surety bond is reasonable. I haven't heard any substantial changes since the initial bond was ordered on November 3rd. The defendant is currently on felony probation and misdemeanor probation. That 2020 conviction is for aggravated assault. I also see a 2018 assault and battery arrest out of Richland County. That's an out-of-state arrest. And I also see a 2015 simple battery arrest. So this defendant does have a violent arrest history and poses a threat of committing an additional crime while out on bond. So the state would argue that the $2,500 bond at this time is reasonable. And because she can't make the bond, that's not one of the IALA factors. Nothing further from the state.
Ms. McLeod, given her history, I think that a $2,500 good bond is a reasonable bond. I'm not willing to change it at this point in time.
Thank you, Your Honor.
Good luck to you, ma'am.
So what that mean?
That means that you were arraigned not guilty this morning, ma'am, and that your $2,500 bond was not modified and is still in place.
So what, have a next court date?
You'll be getting a notification from the division judge of what your next court date will be.
All right, thank you.
Welcome. Have a good day, ma'am.
You too.
Your Honor, may I do Ms. Malloy, position 28, so I can take the ladies back and get position 21, Ms. Hill, please. Thank you. I just need to do.
All right, so she just wants to do one more, so let's.
So I can take them back and get position 21.
Okay, and this is Ms. McLeod's case also?
It is, Your Honor.
And what are we doing with Ms. Malloy today?
She is going to be arraigned, Your Honor, and I would also like to move for her bond to be modified.
All right, Ms. Malloy, good morning. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this, be the truth, the whole truth, and nothing but the truth?
Yes.
All right, Ms. Malloy, you've been charged in case 22 CR 0075288H with battery family violence. This charge carries a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Ms. McLeod?
I do, Your Honor.
How do you plead, Ms. Malloy? Guilty or not guilty?
I don't know how this operates. I just know this between me and my kids and
Okay, hold on.
mental health, so I don't know.
Ms. Malloy, listen to me. You have a right to remain silent. Anything you say can be used against you. It's my understanding that you were going to enter into a not guilty plea this morning. Is that correct?
What I'm supposed to do, Ms. McLeod, I don't know how this goes.
You and I discussed this, the state wants you
I
to
just
serve
hope-
12 months, and you said you were not interested in that.
No,
So
because
I
the
told
man
you
that
you
came
would
to
be.
saw me, it's this guy that came to saw me, and he said that it was gonna be time served, and I came to court, and then I take some classes, and then I was telling him about being about me and my children, and that my daughter is mental health, and I was the one that got stabbed that day, and how she always dissolved my seizure medicine. I got police reports
Okay,
saying that.
Ms. Malloy, hold on. It sounds like you need some additional time to speak with her, Ms. McLeod. So what I'm going to do this morning is, given that she already has a bond in the case, I'm going to give you that additional time until next week to speak with her regarding this matter so that you all can clarify it. Is that acceptable to you?
Yes, Your Honor. It's just that she's a little distraught because apparently someone had spoken to her before and gave her the impression she was going to have time served, but that is not the case from what I understand, Your Honor. And this, of course, was new to her, that the state was asking her to spend a whole year.
Right, well, who was that guy that came and spoke to me and told me that?
Okay, again, Ms. Malloy, I'm not, I don't know, but I'm willing to give Ms. McLeod an opportunity to look into it further before we go further in this matter. So this is going to be rescheduled until next Tuesday so that she can clarify it with you and maybe clarify it with the solicitor's office if there's any miscommunication, okay?
So when I come back to court?
I'm going to come back next Tuesday, December 6th. Okay?
All right.
All right, thank you, ma'am.
Thank you, Your Honor.
Uh-huh.
Your Honor, that concludes my business before the court today. May I be excused?
Yes, am I going to see you this afternoon, Ms. McLeod?
Yes, Your Honor.
Okay, I'll see you then. Who do we have next?
Position 38, raise.
What's the announcement on Mr. Reyes?
A negotiated plea.
Okay, good morning, Mr. Reyes. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? Mr. Reyes?
Yeah, yes.
All right, can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
You said, say again, my bad.
No, you're fine. Do you swear or affirm to tell the truth?
Say it one more time.
You're gonna tell the truth, aren't you?
My bad, the door was open. What you said?
Do you swear or affirm to tell the truth?
Yes.
All right, put your hand down. Thank you, Mr. Reyes. Mr. Duncan, Ms. Duncan?
Yes, Your Honor. In the case ending in 257F for the criminal trespass and obstruction, this is for both counts. The state is recommending 12 months to serve, 74 days, credit for time served, 34 days with the balance suspended, and a stay away from the Salvation Army located at 469 Marietta Street Northwest.
And the only question I had, does the 34 days include the 2 days from before?
Yes.
Okay, then you should be aware that you may be released as late as 3 days from now. As late as 3 days from now. Really. I think he understands the math, and now I understand the math. Thank you.
Okay. Mr. Reyes, it's my understanding that you wish in case 22 CR 0000257F to plead guilty to criminal trespass and obstruction of a law enforcement officer. Is that correct?
Yes. Guilty. Yeah.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation? You're satisfied with what Mr. McLean has done for you?
Yes.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury. You understand that?
Yes, sir.
Has anybody forced you or coerced you to plead guilty? Okay, I'll accept the plea as negotiated. Good luck to you, Mr. Reyes.
Okay.
He's done. Position 25, are you guys ready for position 25, Jackson?
Yes, I think we are. Is the state satisfied on 25?
I think we're still trying to get some clarification. We're having some connectivity issues.
I see. Okay.
Are we ready for position 17 and 18, Mr. Harris?
Has Mr. Murphy joined us? Okay, can we have someone raise Mr. Murphy and give him the intent for today's calendar? Let him know that we're ready for him.
Position,
I've been trying to reach out to him several times. And I'm gonna keep trying again to see what's up.
come on,
And-
Mr. Collins.
And apparently the recommendation is 12 months to serve, so if we have to put this off until next week, we could.
Yeah, can we do position 7, Collins?
Okay, all right, this is a non-negotiated.
That's correct, Your Honor.
I've also requested the live transcript because he's hard of hearing.
Okay. Let me know, is it on?
We got it, we just got it.
Okay, very
Thank
good.
you.
Good morning, Mr. Collins. I'm Judge Eric Morrow. This is the State of Purpose Calendar. We're doing this by video. Do you agree to have your case heard by video?
Yeah.
Can you?
I don't want to eviction of my apartment.
Hold on.
My old lady, she moved all her stuff out.
Stop.
And she said I had to come get my stuff.
Stop.
By the 5th of the.
Stop. Okay.
Mr. Ford, is there something I need to know? Are we,
He's just a
Is
little
he-
hard. He's a little hard of hearing, Your Honor. I had a tough time yesterday, but he's fine.
okay. Mr. Collins, can you raise your right hand for me?
Raise your right hand, Mr. Collins.
Do you swear affirm the testimony you're about to give before this court will be the truth?
You give the truth. I will tell the truth.
Yeah.
Okay, you can put your hand down.
You can read that.
Ms. Salette.
Yes, Your Honor. On November 13th, 2022, Officer Workman with the Hapeville Police Department was dispatched to 515 Central Avenue, which is a Domino's, in regards to an assault. Upon arriving at the location, employees at that location stated that the victim, Martha Butler, was inside of the restroom, and they noticed that she was bleeding. Once the victim exited the restroom, officers observed that she had bruises to the left side of her face, scraped her forehead, left forearm, scratches on her nose, upper lip, and under her eye. And she identified the defendant as being the person who assaulted her. The defendant, the employees on the scene noticed that the defendant also became upset when they told him to leave, and he began kicking the door and kicking over trash cans and screaming when the employees told him to leave the location. The defendant has been convicted of aggravated assault, family violence from 2015, a different victim. But he does have a prior family violence, aggravated assault conviction. I also was able to see a 2013 aggravated assault, a fray arrest, a 2019 disorderly conduct conviction where he made threats to a Juanita Clark, a different victim. I also show a 2011 burglary conviction as well. His latest conviction I see is from October 2022 for theft by receiving and theft by shoplifting, where he's currently on that misdemeanor probation as of October 27th of this year. Due to the defendant, due to his prior history, also to his prior violent history, the state would argue that, well, the state's recommendation at this time is 12 months to serve 120 days, credit for time served 16 days, balance probated, 12-week anger management, no contact with the victim. And that's for the battery charge, for the disorderly conduct, time served, and for the additional 2 battery charges, those would merge into that first count of battery. The state's recommendation is because I did speak with the officer in this case, and she is under the impression that the victim and the defendant do actually live together, that she's been called out to their residence before in the past, but we do not have that information in the report or the warrant. So the DA's office is not accepting this case as a battery family violence felony at this time, but it is our understanding of the facts that this should be a battery family violence felony due to it being his second battery family violence. But it is charged as a battery, Your Honor, and due to that, that is the reasoning for our additional jail time request.
Oh, Ford.
Thank you, Your Honor. We were asking that the jail time be reduced to 120 to 60 days, 120 be reduced to 60 days at this time. As I've listened to the history, a lot of his history was quite dated at this time, Your Honor, and so my client has a part-time job working as a painter with his uncle. He wants to get back to that job at this time. And so I know this is not a bond hearing, but I think it's good for the judge to know that he's a lifetime resident. He has family support. As I mentioned, he is working as a part-time painter. So we're asking only for the reduction at this time of the jail time to be instead of 120 to 60 days.
All right. Mr. Collins, it's my understanding in case 22 CR 00776 you wish to plead guilty to battery and disorderly conduct. Is that correct?
Yeah.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by Mr. Ford. Are you happy with his representation?
Yeah.
You understand you have a right to a trial by jury on these charges. And that by pleading guilty, you're giving up your right to a trial by jury?
You understand that? Giving up your right to a trial by jury? He's reading it, Your Honor. He's just a little bit behind, but he'll
Okay.
respond. Yes. So you're giving up your right to a trial by jury. You understand that? You're giving up your right to a trial by jury. Do you understand that? Do you agree to giving up? Do you agree to giving up your right to a trial by jury?
Oh, okay.
Do you?
Is that yes? You're giving up, you understand you're giving up your right to a trial by jury, Mr. Collins?
You understand you're not gonna have a trial? Say yes, you gotta say yes, can't shake your head. Mr. Collins, you have to say yes. You can't shake your head, you have to say yes. You understand that? Are you giving up your right to a trial by jury? Yes, you gotta say yes.
Mr. Collins?
Yeah.
You don't want a jury trial, do you?
You don't want a jury trial. Say no. Do you want a jury? Do you want a jury trial? Say no.
Okay, yes.
No, you don't want to go.
That wasn't good, huh?
The judge changed the phrasing. He says, you've given up your right to a trial by jury. You understand that? You read that?
Okay.
Say, was it yes? You give up your right to a trial by jury?
Okay.
Say yes. You gotta say yes. Mr. Collins, do you give up your right to a trial by jury? Do you want a trial? Do you give your right to a trial by jury, Mr. Collins? Mr. Collins, do you give up your right to a trial by jury? Yes, say yes.
Yeah.
Okay.
Has anyone forced you to plead guilty?
No.
Okay. I will accept your plea, Mr. Collins. The sentence will be 12 months to serve, 60 days, credit for time served, 16 days. Balance probated, a 12-week anger management program. No contact with the victim, stay away from the incident location. And for the disorderly conduct, it will be 12 months to serve, 16 days, credit for time served, 16 days, balance suspended. I'm going to waive the fees for you, Mr. Collins, while you're on probation to help you get and stay on your feet. But you're going to have to be on probation for the entire 12 months.
You
Good
understand?
luck to you, sir.
You understand? The judge reduced your jail time. That's 14 days. Okay?
12 months.
That's probation. 12 months is okay. But you'll be let out in 14 days.
Okay, who do we have next?
14.
Position 20, Mr. Herrera. He needed a Spanish interpreter.
Okay. Thank
Is there one available?
you. Thank you too. Thank you.
Do we have a Spanish interpreter today? Okay.
Your Honor, if we do have a Spanish interpreter, I was not able to speak to Mr. Fair at all. So if we do have a Spanish interpreter, I was just gonna reset it, but if we have a Spanish interpreter, if there's
Well, we don't, given that we need it, I mean, you're gonna need time with the interpreter, Mr. Ford, and that's gonna be difficult to do. Regarding if this is not gonna be a time served, would you like to put this on next Tuesday's calendar to give you the opportunity to adequately speak with him?
yes, what number was, what position was it?
Position 20.
20, okay. Your Honor, I think that's fine. I think that's something that, with my limited Spanish, I was able to. Yes, yes, Your Honor. We can reset that to next Tuesday.
Okay, we'll reset him and let's see if we can have you speak with him with an interpreter prior to that time. All right, who do we have next?
Are we ready for position 25, Jackson?
Have we heard anything from Mr. 25?
Yes.
I believe Ms. McCutcheon was trying to be let back in.
Yeah, I'm on, Judge. Judge, we've not been able to look at the accusation. I've looked in Odyssey. I cannot see the accusation. I know it's an older case. The document apparently is not scanned. Respectfully, does the court have a copy of the accusation? I wanted to inquire as to who is named in both counts as the named victim.
This is for position 25.
Kenan Jackson?
Okay, yes. Let's see, thank you. The name in the accusation is Najur Bowser, Najur Bowser.
Okay, yes, Your Honor. And is that for both counts?
Both counts.
All right, thank you, Your Honor. And that is the death certificate that Mr. Klain provided that shows that that victim is deceased. So the state will present a null pros as to that case.
Okay, very good. Thank you, Ms. McCutcheon.
I'll present that and send it. Is it Ms. Lewis or Mr. Jordan today?
That's Ms. Strong today.
Oh, Ms. Strong. All right, thank
Yes.
you.
All right. So you got that, Mr. McLean?
Yes, thank you so much.
All right, very good. Where are we going next?
Are we ready for position 17 and 18, Harris?
Have we been able to raise Mr. Murphy?
We're checking.
Judge, I've been trying to reach Mr. Murphy for the last 10, 15 minutes to see if
Okay.
something had happened, and he has not been picking up his phone.
Okay, so this is, we're gonna have to reset this till next Tuesday, to December 6th. And it's a 12-month to serve recommendation by the state, so we will give Mr. Murphy the opportunity to be present. Courtroom 2. Did you get that?
Judge, can you repeat that again?
Yes, we're gonna reset Mr. Harris till next Tuesday to give Mr. Murphy the opportunity to appear.
He said he wants to go pro se, Judge.
Well, I prefer that Mr. Murphy's already spoken with him. This is a 12 months to serve sentence. I would prefer that that we give Mr. Murphy that opportunity.
So he's been reset, Judge?
Yes, reset till next Tuesday.
Okay. He wants to do he still wants to go pro se, Judge.
Okay, well, I'm not going to allow that today, given the nature of what he's charged with and the sentence. I would prefer to have Mr. Murphy speak with him in that regard and give Mr. Murphy the opportunity to address the court since he is counsel of record on this matter.
All right, and we're completed here in courtroom 2, Judge.
Okay, what about, let me make sure, so all the other ones are, let me just make sure before I let you go. All right, I think that's it, except for position 40, Rashawn Tanner.
Position 40. Oh, yes, I'm sorry. Yes, we did have, he's from Cobb County, Judge.
Okay. So this is gonna be a plea.
Yes, Your Honor.
All right. Good morning, Mr. Tanner. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir, I do.
Thank you. You can put your hand down, Mr. Tanner. Thank you. Ms. Duncan?
Yes, Your Honor, in this case ending in 2472E criminal trespass, the state's recommendation is 12 months to serve, 109 days, credit for time served, 109 days, with the balance suspended and a stay away from the location of 180 Walker Street, which is No Mas Cantina.
You're on mute, courtroom 2, Mr. McLean.
Yes, Your Honor, he's going to, as part of his, he is asking the court to accept the negotiated plea. He will be staying away from 180 or 184 Walker Street, No Mas Cantina. And he asked the court to give him time served, balance suspended. He stipulates to venue ID and factual basis, and he does understand the terms.
Mr. Tanner, it's my understanding in case 22 CR 002472E, you wish to plead guilty to criminal trespass, is that correct?
Yes, sir, I do.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
As far as I can be? Yes.
You understand that you have a right to a trial by jury on this charge, and by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Is anyone forced or coerced you to plead guilty?
No.
I'll accept your plea as negotiated, Mr. Tanner. Good luck to you, sir. Okay,
Yes, sir.
all right. Okay, I believe that takes care of the 9 o'clock calendar.
Yes, Judge, we're completed here in courtroom 2.
Okay, I'll see you this afternoon. Thank you.
Okay, see you this afternoon. Thank you, Judge.
Let's see, and when you all are ready, we can go over the calendar with Ms. Strong when she's ready.
We're all set, Your Honor.
Okay, we're waiting on Ms. Strong. She's getting the paperwork
All
together.
right, it's fine. Just one minute. All right, that's fine, that's fine. Of course. Okay. No, I've got different versions of that. You contact you. This is
All right, so. They're right there for me. So everybody else is misdemeanor, right? All misdemeanor. We're gonna take you back. I'm back, they're gonna take you back.
You know, it's in the shoes.
Remember hearing them of verse 21.
I don't know. I can't do it in this emergency. So
Yes.
No.
Position 21.
I didn't hear 21.
Oh, you know what? Actually, I think that we had one more in the South Annex. Is the South Annex on? Who represents position 21, Ms. Hill?
I do, Judge. And in fact, okay, is she there, Miss?
Yes, sir.
Okay, Judge.
Come on, Ms. Hill, have a seat over here.
There's something else. What is it?
All right. Good morning, Ms. Hill. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you. Mr. Howard, what are we going to do with Ms. Hill today?
Judge, this is just going to be an arraignment. We don't need to address bond.
Okay. Ms. Hill, you have been charged in case 22 CR 001436A with disorderly conduct and obstruction of a law enforcement officer. Each of these charges carries with it a maximum penalty of 12 months in jail and or $1,000 fine. Do you waive formal reading of the accusation, Mr. Howard?
Yes, Judge.
How do you plead, Ms. Hill, guilty or not guilty?
Not guilty.
We will record your not guilty plea. Your case will be returned to the division judge and you'll get notification of your next hearing date. Good luck to you, ma'am.
Thank you.
Thank you.
Judge, if I could inquire while Ms. Milton is there, there was one other, is there Ms. Reese? Heather? Reese?
We took care of the Reese case.
Okay. Okay, she's already been taken care of. All right.
Yes, number 37 is not guilty, arraigned, waive the reading of the accusation.
Okay, thank you.
They didn't vote on
Is this the,
it.
what calendar is it?
You should have.
I don't.
Can we deal with him once the calendar's over? so that we can release everything.
For James Love.
Is there no DD bench warrant calendar today, Your Honor?
I don't have one before me, so
Okay, let me get your first person. Come on, Mr. James, right? I got Mr.
Oh, is- okay. I'm being handed one now, so.
I can go to the SAP calendar so that everybody else don't have to wait.
All right, so let's go over the SAP calendars.
Okay, position one was not guilty, waived jury by the attorney, position 1 and 2. Position 3 was a plea. Position 4 was not guilty, arraigned, reset jail jury. Position 5 was reset to 12/1/22 SAP. Position 6 was a 5,000 surety bond set. Position 7 was a plea. Position 8 was a plea. Position 9, amended bond order, 5,000 sign-on bond in jail. Position 10 is not guilty, arraigned, reset jury. Position 11 was a plea. Position 12 was a plea. Position 13 and 14 were released. Position 15 was reset to 12/6/22 SAP.
Your Honor, I emailed a transfer order to Ms. Strong for position number 15.
15, okay. Is a transfer to the DA?
Yes,
Okay, thank you.
thank you.
Position 16 was released. Position 17 was reset 12/6/22 SAP. Same with position 18. Position 19 was a plea. Position 20 was reset 12/6/22 SAP. Position 21, not guilty, arraigned, reset jail jury. Position 22 and 23 were pleas. Position 24 was a plea. Position 25 was no pros. Position 26 and 27 were pleas. Position 28 was not guilty, arraigned, but it's still reset to 12/6/22 SAP. Position 29 was a plea. Position 30 and 31 were pleas. Position 32 was reset jail jury. Position 33 was a plea. Positions 34 and 35 were reset to 12/6/22 SAP. Position 36 was a plea. Position 37, not guilty, arraigned, reset jail jury. Positions 38, 39, and 40 were pleas.
Mr. Jordan, I think 36 was, their bond was reinstated.
Oh, I don't have the bond amount.
No, the old bond.
I'm sorry, you're right, it was. I wrote a plea down, but that was the one that we needed the bond order for.
Yeah, Mr. Howard, yeah, you already discussed that.
Oh, thank you. What was the bond amount?
Two, three, four, five, six.
Any other questions regarding the calendar?
Yeah, Your Honor, number 10, I thought number 9 and 10 were both signature bonds, SOB, $5,000. 9 and 10.
So I'm sorry, so position 9.
They're the same person.
Is the same person. He is only holding on the FTA case. That's the one, it was a 5,000 surety bond that was switched to a 5,000 sign-on bond to the jail. So make sure the bond order has the FTA case on it, not the CR case number.
Okay, I thought the judge gave both SOB for the $5,000 on both 9 and 10.
So he's not holding on position 10. So if you make it a $5,000 signature bond, that means the bond come back and get their bond on that.
Okay, so the bond's not affected on number 10.
Correct.
And so we just gotta do the FTA, which is number 9.
Yes, that should be the case number that's on the bond order.
Okay, thank you.
You're welcome.
Any other questions on the 9 o'clock calendar? All right, if not, let's move on to the DV bench warrant calendar. Position 1, Tiffany Jones.
Good morning, everyone. Good morning, Your Honor.
Good morning, Ms. Jones. Who represents Ms. Jones?
Myself.
Okay.
That's correct, Judge. I qualified Ms. Jones yesterday. She's not going to qualify for our services.
All right. Let's see. Let me see who else is on the line. Position 2, Dennis Trailer.
Yes, ma'am.
Mr. Trailer?
Yes, sir.
Oh, okay. He's in court with us. Has someone spoken with him?
No, Judge, I left him several messages, but I didn't receive a return. And I'm not physically there. I can call him if that cell number is still the best number.
Mr. Trailer, do you have a phone on you?
Yes, sir.
Okay. Can you give us your phone number so that we can give it to counsel so he can call a public defender to represent you on this?
Ms. Brown, we're gonna get married.
Okay. I don't want to hear anything.
849-2426.
And sir, if you could just step outside, somebody's going to call you. Mr. Howard's going to call you, okay?
What was the number he gave, Judge?
Oh, I'll take it.
Mr. Jordan's going to text it to you.
Okay, all right.
And Johnny Wilson.
Yes, I do see Mr. Wilson under Tiana Smith, Judge. He's muted, but he does qualify for our service. I'll be representing him.
Okay, so let's go ahead and deal with Mr. Wilson to start. Let's see. Good morning, Mr. Wilson. I'm Judge Eric Morrow. Can you unmute yourself for me?
Yes, sir.
All right, very good. Thank you. Mr. Howard, have you had the opportunity to speak with Mr. Wilson?
I have, Judge.
Okay, and what's the issue?
Judge, Mr. Wilson missed a plea and arraignment date on October 25th. And in speaking with him, and actually his wife as well confirmed that it was only
the wrong phone number.
It was only after that court date that they were advised by their by his pretrial officer that he was had missed the court date. They immediately went down to try and rectify the issue. And I spoke with the pretrial officer, Ms. Hayes, this morning as well, and she did confirm that Mr. Wilson's been reporting to pretrial with no issues. She was surprised as well because when he reported in October, had been known about the court date, that she would have in fact, mentioned it to him or reminded him of it, but neither of them were aware of it, Judge. And so he didn't appear only because he says he had no notice of the court date. He has every intention of showing up to resolve the case. He's had some medical issues that he suffered with, which is why he's seeking disability at this time. And based on the household income, he would qualify for our services. So Judge, this appears to be a case where he just did not get notice. I do know that the system indicates a notice went out, but both he and his wife, who lives at the same address, because they do have a no further violent contact order, they both indicated that there was no notice, and the pretrial officer confirmed she didn't get notice either. So we would ask the court to set aside the bench warrant in this case.
Did the notice go to this address that's in the system?
It appears from what Ms. Lewis sent me that a notice was noted to have been sent to the current address at 6226 Means. However, they indicated when they went down after the pretrial officer notified them that the court date had been missed, that there was a McDonough address on the system at that time. But the address that the notice was supposedly sent to is the address that they currently live at. But both pretrial and the customer, and Mr. Wilson claims that they never got the notice.
Okay.
And
Ms.
Your Honor,
Duncan?
it's the state's contention that this defendant did, in fact, Mr. Raymond in front of Judge Taylor on October 25th, 2022. In the file, there is no indication of a return to sender. However, we do see a releasing motion. However, that is the same address as everything was sent to. So the state's position is defendant's responsibility to make sure that they keep the correct information imported with the court so that they can be apprised of all future court dates, especially in circumstances such as these. So the state would request that the bench warrant not be set aside and that the defendant be remanded into custody.
Okay, I'm going to give him the one opportunity as the court normally does. So I'm going to set aside this one. Mr. Wilson, you're going to have to make sure that that you don't miss any other court dates. They will send the notice to where you have told the court that that you reside. So you might want to keep in touch. But as far as this goes, I'm going to let you use the one time to set this warrant aside. All right. Good luck to you, sir.
Thank you, sir.
And Mr. Howard, if you'll prepare that for the court.
Yes, Judge.
Okay. And Mr. Trailer is awaiting your call, Mr. Howard. So just let us know when you're ready with him. Let me go to Ms. Jones. Ms. Jones.
Yes, Your Honor.
Good morning again, Ms. Jones. I'm Judge Eric Morrow. You have been charged in case 22 CR 005626A with battery family violence. Also, you have a right to remain silent. Anything you say can be used against you. Let me first go to Ms. Select. Did Ms. Jones miss a court date?
Yes, Your Honor.
Would you please tell me about that?
Yes, one moment, Your Honor. That court date, she missed a plea in arraignment on October 31st, 2022, before Judge Roth. She was released on bond on August 23rd, 2022. I do see here where she did file an address change on October 5th, 2022. I'm not sure when the notice was mailed out, and I'm not sure what address the notice was mailed out to. But I do see here on what she filed on her, this new address is on her license that was issued on August 29th. And she didn't submit her address change until a month later after that license was issued. Based on the fact that she missed the court date while out on a signature bond, the state would be asking that you not set aside the bench warrant and remand her into custody. But I do understand the discretion of the court, Your Honor.
Okay, I just want to make sure, Ms. Jones, you did change your address on October 5th with the court, is that right?
Yes, Your Honor. I never received any notification in the mail at that address. And my PTO, she gave me the original court date of November 21st, and she didn't get any notification either. She notified me on November 18th that I had a court date on October 31st, which neither one of us knew about. So I went straight down on that day to get this reset.
Okay, I'm going to give you the opportunity also. Would you please put your address in the chat for us so that I can confirm with the clerk that that is your correct address that we have on file. So for this one time, I will set aside the warrant, the bench warrant.
Thank you, Your Honor.
And when you get that, will you just confirm it with what we have on the file before I let her go? All right, before I let you go, Ms. Jones, I'm gonna confirm that that is the address that we have on file for you.
Thank you.
Judge, I just confirmed it is correct.
Okay, all right, thank you, Ms. Lewis. All right, Ms. Jones, so we'll set that aside. Please keep in touch with the court if you have any other changes of address, okay?
Yes, Your Honor.
All right, you have any questions for me?
No, I'll just get another court date in the mail.
Yes, correct. All right, you have a good day, Ms. Jones.
Thank you too.
Thank you. Okay, so the final case, position 2, Mr. Howard's speaking with him right now. So as soon as that's concluded, we'll take that matter up. The court will be in recess until that time. How y'all doing today? Good morning, Mr. Traylor. I'm Judge Eric Moore. Let's see. Where are we on this, Mr. Howard?
Yes, Judge, Mr. Traylor will qualify for our services. And in speaking with him, he missed court on September the 2nd. However, the address it was sent to was an old address where he lived with his wife before she passed away a few years ago. I believe it was the address on his ID at the time of his arrest. However, once he was notified that he had missed court, he came down and changed his address on November the 21st to the current address, which is on the system right now. So this was not an instance where he willfully didn't show up to court. He acknowledges that his license didn't have the most current address, but it was not a situation where he was somehow trying to delay the process or trying not to answer the charges. He did update his address, so we would ask the court to set aside the bench warrant now that we have the correct information for him.
Ms. Duncan?
Your Honor, it's the state's contention that this defendant did have TA for arraignment in front of Judge Morrison on September 2nd, 2022. In the case file, there is no return to sender. There is a regular address change, as Mr. Howard stated, that was completed on November 21st, 2022. That address is the same address that was placed on the bond order with a stay away from Renee Brown, issued by Judge Mincy on January 10th, 2022. And that is the Donald Lee Hollowell address. It is the state's contention that it's not this defendant's first rodeo with the court. He does have other prior and subsequent offenses. So we believe that given the facts as stated by the state at this time, we believe the bench warrant should not be set aside and that the defendant should be remanded into custody.
And Judge, by way of clarification, the notice that was sent to Mr. Traylor by Judge Morrison's case manager on August the 10th has a 14 Johnson Road Northwest, apartment 5105, Atlanta, Georgia address. So the notice that was sent for court was sent to a different address than is the address that it was changed to, and the address maybe that was given on his bond order. But of course, that doesn't necessarily change it in Odyssey because it's written on a bond order. So it was a different address, Judge. I just want to make that clear.
And to clarify that Johnson Road address, I did just clarify while we were waiting for the court to proceed. That is on the open DUI cases. As far as this case, there is no return to sender, and the address change that I located for this case file was on November 21st, 2022, and it's the same address as on the bond order.
Okay, so we do have this current address, is that right?
Yes, Judge.
All right, I'm gonna give you the one opportunity, Mr. Traylor. So you've missed court once. I'm gonna set this bench warrant aside this one time. If you miss court again, then it won't be set aside, okay? So
Okay.
just make sure that that if you do move, that you update your address contemporaneous before you move, okay?
Yes, sir.
All right, good luck to you, sir. You'll be getting a notice for your next hearing date.
Okay.
All right?
Thank you.
Okay, thank you all. I believe that concludes this morning's calendars. Any questions, concerns? No, if not, thank you all so much. I'll see you all next week.
Thank you, Judge.
Thank you, Judge.